everybody. Hello. Good afternoon. Yes, welcome back. Hello, Rosie. Good to see you. Thanks for coming back. Hope everyone is doing well. Good to see everyone back again. Hello. Yes, a little bit busy today, but not too bad. Gotta carefully keep my schedule in place. So yes, just starting. Yes. Oh, well, good. Yes, good to see everybody back again today. So welcome, everyone. Thank you for joining me. I've got a few things to go over tonight. Should be interesting, I think. Yes, tonight we are going to be going through the superseding indictment. I've made lots and lots of posts on it, but I thought I would go through this and kind of look at the evidence, kind of like I did with the DC indictment, and kind of walk through the sources of probable cause, how it would be presented in trial, and those kinds of things. Yes. It seems like we've got a little bit more every day, a little bit different. Telenovela. Oh my goodness. I'll have to be more dramatic, I think, to be an authentic telenovela. But yeah, there was some interesting things that kind of came out today. And is this your specialty practice? I have a pretty big background in criminal law and constitutional law and evidence. So those are really my areas that I've spent a lot of time focusing on. So yes, I'm not sure what's going to happen with Georgia at this point. There's a lot of things going on. I think there's actually a hearing tomorrow that's going to be going on. So we'll kind of see how that plays out. Yes, I'm just getting started here, just kind of having everyone join me tonight. But I will be going through the superseding indictment and taking a look at the evidence and kind of going through and talking about probable cause and those kinds of things. So you haven't focused much on your life. Well, actually, I have multiple people in my world who are extremely busy. This time of the year, right before we go back to school, is a pretty busy time. So everyone's kind of doing their own thing. But so that's why I've been able to kind of carve out a little bit of extra time right now. But I think after I've got about 2 weeks left, and then after that, things are going to get pretty chaotic. But we will see. We will see what happens. Hopefully nothing big comes down, but yes, there are we do have a lot of interesting people in the comments, so please be courteous. Appreciate that. Yes, a superseding indictment is where you have an indictment that was on file, and we had the original indictment filed back in the beginning of June. And then more evidence came down from the grand jury stating there were new charges. So we had a couple more counts added, and then we had a new defendant added along with a new section of the code that was added. So the government, rather than putting in a different or a new indictment, put in what we call a superseding indictment, which is the original indictment plus. So it has the additions of the new evidence for the new defendant and the couple of extra counts that came in. So yes, we'll be going through the evidence, but because new evidence was given to the grand jury, they came down with probable cause for these new counts. And the evidence that was added was the security tape, and we'll get into that. But that kind of information is what was included, which added to this new section here of the code. And and then added the third defendant as part of the conspiracy. So these were all added, and so that's what makes it a superseding indictment. So it comes in and replaces that original indictment with these new charges and new counts. What do you think of Cannon talking about the DC jury? You know, I thought it was interesting. I'm not really sure what her position is. I'm undecided about her at this moment, but, sometimes our judges will kind of help out our defendants a little bit, but typically it's not in a case of this caliber. So can't charge the president. No, that's not true. You can charge anybody, Supreme Court justices, presidents, vice presidents, it doesn't matter. And it may fail. It may fail. We're talking about probable cause. We're not talking about proof beyond a reasonable doubt. And I will be kind of going through the evidence tonight and talking about where our probable cause is here. Yes, yeah, and he's not at the moment. Oh, you did your nails. Oh, good for you, good for you. A little self-care, good, excellent. Can who be removed? The judge? Any of our judges can be removed if there's a showing of a good cause in the situation. We don't have any of that right now. We don't have any information that would be at that level, but I'm sure the government's pretty careful about, what's allowable and what's not allowable for a judge to be able to do. Well, Kevin, you're free to scroll on by. If this isn't your cup of tea, that's no problem. Do you think he's going to jail? That's a tough question. We don't have a conviction. We don't have proof beyond a reasonable doubt at this point. So that's kind of hard to predict. Sitting president going after a political opponent through his DOJ. Yeah, that's just not true. I mean, I understand that's a lot of people's opinions, but that's not based in facts. Yes, well, let's keep this PG here, all right? It's a family show, kind of. It's kind of a family show. This is about election interference. Well, this particular case in Florida that we'll be going through tonight is not election interference. This is classified documents. The election interference, I guess, and I don't really call that election interference. I call the obstruction of a government proceeding case is the Washington, D.C. one. They have no crime. Basically, it goes back to he said, she said. For which case, Kevin? Because I don't know of any she says in any of the cases. Maybe you're talking about the defamation case. I mean, I don't really know. Or the New York case, maybe. Times of view. Yeah, that's a good point. Can we charge everyone for crimes against humanity? Well, we have laws, so if you violate a law that is a crime against humanity, then yes, you can. Absolutely. Thank you for educating. Oh, you're welcome. You're welcome. Happy to do so. I'll just take just a couple more minutes here to kind of chit-chat, and then I will jump right on back in. Oh, yes. Renewable energy sources are always needed. Always needed. What did you call it? Well, yeah, I mean, I don't... Oh, thank you. Thank you so much. Yes, we are a nation of laws. I mean, if you can say nothing else, I mean, you can say that. And he said it was fraudulent. Same kind of... I have no idea what you're talking about, Kevin. I really have no idea. Can't really respond when I've got no clue what you're talking about. True, but we've got rules regarding how much you can pollute or speed. So as long as you keep it within the purview of what the law says, you're fine. Could you talk a little bit about how jury selected? And people are confused with that. Yes, our jury selection process has multiple levels. We've got questionnaires, and then we also go in and go through a voir dire process in order to find our most non-biased people as humanly possible. Everyone's got some bias, but we still need to pick our jury, and we've been able to always find a jury for anyone who has ever been charged. We've always found a jury. So, do I work for the Dems? Oh, no. No, 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 no. I work for no party. I have no party affiliation whatsoever, particularly when I'm talking about the law. Nope, none at all. Thought I saw somewhere that January 6th committee lost all the evidence. Nope, nope. The January 6th committee didn't have all of the evidence. They weren't given all of the evidence. They weren't shown all of the evidence. Let me give you an example of if you think back to all the people that testified. Vice President Pence did not testify. They subpoenaed him, but he chose not to testify. So his testimony that we see in the D.C. situation, none of that information did the committee have. All of that came from the prosecutor when he was able to subpoena the vice president. So that's an example. So this particular indictment is going to be going through the superseding indictment that is in Florida. This is what the arraignment is for tomorrow. And I wanted to kind of walk through the evidence here, talk about probable cause. I think so. Yeah. And just kind of go through the probable cause elements and how we establish that. Our grand jury has to find a probable cause in order to have any counts involved. So we'll kind of talk about that and what people think about the evidence. Right. They've got to have evidence of probable cause to indict. Now, that's not proof beyond a reasonable doubt. That's probable cause. So we will just kind of go through the evidence here, just kind of one piece at a time and take a look at it and kind of sort out our different levels of probable cause. I'm trying not to skip through any tough questions, but the superseding indictment. Yep, you're close. You're really close. Yeah. Yeah, an arraignment, sure. An arraignment, okay, so let's take it back one step. When we've got an investigation, a particular person committed a particular crime, then they are brought in. Typically, they'll go into jail, which means they need to be seen by a judge within 24 to 48 hours, depending on jurisdiction. We call that typically an initial appearance. But if you're just charged in a situation like what we've got in many of our cases, actually, then you're given an arraignment date. So you come into court, and that's when you enter your plea of guilty or not guilty. And then from there, we set it for trial. So the arraignment is when you just go in front of the judge and you say, guilty or not guilty. And then we go forward. So that's really what the arraignment's for. It can go hand in hand with this other proceeding that we call the initial appearance. But it doesn't always happen. Yep. Do I believe that all the other co-conspirators will be charged? I think there's a plan. I have no idea what that plan is, but I think there's definitely a plan. And there were a lot of people that have allegedly broken a lot of different laws. So I don't think the charges are done. January 6th was freedom. Well, I guess if freedom is breaking the law, then yeah, I guess you could go with that. But that's what we've got going on. That's why we've got a grand jury indictment. So, nope, I don't think one party or the other party should have the power. I'm about, the people should decide who has the power. So that's kind of, you'd rather people trash a city. I've got no idea what you're talking about, Kevin. Trashing a city. All I know are people who were doing illegal activities, and hundreds and I think upwards of 1,000 were charged and convicted. So that's what I'm talking about. I don't remember the riots by the leftists, Kevin. I don't. I mean, I remember seeing almost 1,000 people charged. I remember that. But yep. No, I do understand the First Amendment, and I think that's why people get frustrated with me, and I understand, but, I didn't write the First Amendment or the doctrine. I'm just explaining to you what it is. It's not my opinion. It's just the law. No, I have no idea, Kevin, and I'm going to need you to calm down a little bit here. We deal with facts. We deal with political speech, but completely unsubstantiated falsities are not permitted here. So Yeah, I'm going to need you to just calm down. Thank you. Sure. Sure. Yes. Kevin, I'm not here to argue with you because this is my off time, my man. So I don't want to block you, but I will. So I'm going to need you to calm down a little bit, okay? Why don't you take a little break? This isn't the First Amendment here. I'm not the government, so First Amendment doesn't apply here. If you want to fight, that's fine, but let's take a little break. I've got other people involved here, not just you, Kevin. Unless it's your side, it's not true. Okay. Well, I mean, am I going to mute you? Is that have to do that? If I mute you, are you going to come back and be okay? We'll see. Okay. Sorry about that, but I got other people here. I try to be as fair as possible. I try to give lots of warnings to everyone. And again, I don't mind other comments and even people that disagree with me. I think that's fantastic. I always enjoy people who can give me a different way of looking at things because that's how I learn also. So I think that's important. So yeah, I try not to block. I try to just mute just for a little while, but also I'm trying to kind of give everybody a chance to come in and learn about different things and stuff. So, all right. Yes. Okay. Well, let's go ahead and start down our fun path here of looking at the evidence. Again, this is the superseding indictment that came out of Florida. This was filed in July of 2023. I've done several posts on this. So if you're interested in the actual wording of every single thing in the superseding indictment, I have multiple posts on that. So you can go and take a look. Tonight, I do want to go through it, but I want to kind of go through it in a way that we can talk about the evidence and let's talk about how credible the evidence is and what we think. So, people are talking about me all over TikTok. Oh dear. I don't know if that's good. Yes. Well, oh my gosh. I tell you, I think I have some of the best people in my comment section. You guys are always so fun. I enjoy you. Even if I completely disagree with you, I still enjoy your time. So, all right, let's dive in here. Superseding indictment. So this means we've got the original indictment in here, but we've got some additional counts that were added, some additional charges that were added. So I want to go piece by piece to really talk about the evidence in this case, and we're going to be talking about probable cause because that's the burden of proof needed for a grand jury indictment. So probable cause is kind of on a spectrum. We have probable cause being kind of this middle of the road. It certainly is not proof beyond a reasonable doubt, but it's more than reasonable suspicion. And reasonable suspicion is what's needed for stop and frisk. And so probable cause is more than that, but of course then less than proof beyond a reasonable doubt, which is how we find our guilty verdict. So let's hop in here. We've got defendant Donald J. Trump was the 45th president of the United States of America. He held office between January 20th and 2017 until January 20th of 2021. As president, Trump had lawful access to the most sensitive classified documents and national defense information gathered and owned by the United States government. So I think this key piece here is the ownership, who owned these documents, including information from the agencies that comprise the United States intelligence community and the United States Department of Defense. So we are establishing how we've got access in the beginning to these classified documents. Over the course of his presidency, Trump gathered newspapers, press clippings, letters, notes, cards, photographs, official documents, and other materials in cardboard boxes that he kept at the White House. Now, in order for them to make this kind of statement, of course, you're going to have some kind of evidence. So we don't just have, this random statement of, he kept all of these things. They're going to have proof that he had newspapers and all of these different things and that he did keep them in cardboard boxes. So as we go through this, we're going to be watching for the proof that they have, the evidence that they have of this kind of material put into cardboard boxes. Among the materials Trump stored in his boxes were hundreds of classified documents. Now, that's an element that's needed for the federal code section that's been charged here. So the classified documents Trump stored in his boxes included information regarding defense and weapons capabilities of both the United States and foreign countries. The United States, these kinds of programs, potential vulnerabilities of the United States and its allies to military attack, and plans for possible retaliation in response to a foreign attack. The unauthorized disclosure of classified documents could put at risk the national security of the United States, foreign relations, the safety of the United States military and human sources, and the continued viability of sensitive intelligence collection methods. Again, we're establishing these critical elements for the code sections. I will be going through the code sections here and explaining again the elements that we're looking for as we go through the evidence. All right, at 12 p.m. January 20th, Trump ceased to be president. As he departed the White House, Trump caused scores of boxes, many of which contained classified documents, to be transported to the Mar-a-Lago Club in Palm Beach, Florida, where he maintained his residence. Trump was not authorized to possess or retain those classified documents. All right, so let me take a minute and grab the code sections, because that's really the key to this case, is how the law is actually written. So on the very first page of the indictment, of course, we have our code sections listed here. All of the code sections that they're claiming have been violated. And so by looking to that code section, we can see exactly what the requirements are for the elements that need to be proven beyond a reasonable doubt. So counts 1 through 31 and then 32 that was added in the superseding indictment. If we look here, we've got code section 793, and let me flip here to this section. This is the subsection that we're talking about. This is what he's been charged with. Whoever having unauthorized possession of, access to, or control over any document, writing, codebook, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument, appliance, or note relating to the national defense, or information relating to the national defense, which information the possessor has reason to believe could be used, there's an intent element there, to the injury of the United States or to the advantage of any foreign nation, willfully communicates, again another intent element, delivers, transmits, or causes to be communicated, delivered, or transmitted, or attempts to communicate, deliver, transmit, or cause to be communicated, delivered, or transmitted the same to any person not entitled to receive it, or willfully retaining the same. This is one of the big things that a lot of people talk about is they're like, well, all the other presidents had classified documents, and that's true. But in this situation, the other presidents returned those documents when they were asked. And in this situation, he did not. So it's this element of willfully retaining these documents after he was asked to turn them over that's one of the key issues here, and fails to deliver it to the office or employee of the United States entitled to receive it. So this is a specific section of the code. This is where we have all of the elements that are needed. And I broke them down just how we would normally break down any criminal code section into just the elements that we have to prove to the jury. We would have to prove unauthorized possession or control, had reason to believe that it could injure someone by having this kind of information, communicates, causes, or attempts to anyone who's not authorized, willfully retaining it, and then failing to deliver. So these are the elements that we're looking for to find the probable cause in order to go forward on the case. No, they didn't change the law after they came in. This has been a law for quite a while. Yes, if he had given them back, he would have been okay. Yep, absolutely. Absolutely. Yep. Okay. Let's just Trying to keep one eye on the comments here. All right, back in we go. So those are the elements that we're looking for. So as we go through our different pieces of evidence here, we'll be looking to fill in each of those elements that we would be needing to prove beyond a reasonable doubt to the jury. Oh, a real quick pause. Sorry, Jilly Bean. Yes, I had hopped on earlier because there had been a couple of updates that had been filed, a couple of things that I felt were a little hinky. And based off of my research, talking with other people, I think we all kind of conceded that it's a little hinky, the filings, but not a harmful error. So I think it's better to just kind of wait and see what happens. Just as an update to anyone who was here earlier. But yeah, I had just noticed a couple of Florida filings that just seemed a bit odd to me. But then on further inspection, I think I'll wait a little bit to decide for sure what's happened. Malicious intent to prosecute. I've got no idea. That is a crime, and you can prove that. No, nope. There's a law that says you can't have the documents. So you can't just keep documents if there's a law that says you can't. No misprint. No, I don't think it was a misprint. It could have been a clerical error, but I'm not sure it was damaging. All right, so that's a quick side note for everyone who had joined me earlier. All right, let's hop back in here. So he ceased to be president as he departed. He caused scores of boxes, many of which contained classified documents, to be transported to the Mar-a-Lago Club in Palm Beach, Florida, where he maintained his residence. Trump was not authorized to possess, retain those classified documents. Again, that's one of the elements needed for that section of the code. The Mar-a-Lago Club was an active social club, which between January of 2021 and August of 2022 hosted events for tens of thousands of members and guests. After Trump's presidency, the Mar-a-Lago Club was not an authorized location for the storage, possession, review, display, or discussion of classified documents, which is all set out by statute, was required for classified documents. And they'll go into it here in the indictment in just a little bit. Nevertheless, Trump stored his boxes containing classified documents in various locations at the Mar-a-Lago Club, including in a ballroom, a bathroom, in a shower, an office space, his bedroom, and a storeroom. So this is page 2. I just want to make sure I'm getting everything in correctly. On 2 occasions in 2021, Trump showed classified documents to others as follows. Now again, I pause here because that's one of the elements that was listed out in the code section, right? So we have this piece here. We're willfully communicating to people who are not authorized. That's a piece of this code section. That's why it's important to have that piece in there. So let's take a look at the evidence here. In July of 2021, at the Trump National Golf Club in Bedminster, New Jersey, during an audio recorded meeting with a writer, a publisher, and 2 members of his staff, none of whom possessed a security clearance. Let's pause there and talk about that evidence. We've got an audio recorded meeting. So in order to get that admitted to our jury, so our jury could see it, we're going to need the writer, publisher, 2 members. So each of these people can be a witness that we would call to testify and to also put this audio recorded meeting into the record. Trump showed and described a, quote, plan of attack that Trump said was prepared for him by the Department of Defense and a senior military official. Now, again, when they're talking about the evidence here, they're saying we've got an audio recording of these words being used. Hence why we've got the quotes. So that's some pretty significant evidence. Yes. Oh, yes. We just need to look to the evidence. Again, this can come into court if it's so long as it's introduced properly through the right witness. Trump told the individuals that the plan was, quote, highly confidential. That shows his intent. Did he know that the page that he was talking about was confidential? Well, he said it himself. So that inference could be made. And, quote, secret. So again, these words, and this has all been recorded, Highly confidential and secret goes to his intent. Did he know that the document should not have been shared? That could be an argument made to the court. Trump also said, quote, as president, I could have declassified it, meaning he could have, but he didn't, meaning he understood that it was classified because he did not declassify it. And now I can't, but this is still a secret. Again, going to his knowledge that the document was classified. So if he comes in and tries to use the defense of, hey, I didn't know it was classified. Like, well, you did. You said it yourself, that it was highly confidential and secret. And then he can say, well, I declassified it. And they're going to say, no, you said you could have declassified it, but now you can't. So the inference between using your own words can show whether or not you declassified it, although even our declassification doesn't work that way. The actual process involves more than that. But I'm just saying, if that's going to be his argument, then the other side's argument is going to be, well, these are your exact words. And that inference then is for the jury to decide the credibility of. All right. In August or September of 2021, at the Bedminster Club, Trump showed a representative of his political action committee who did not possess a security clearance. Again, that's easily proven by just calling this person to the stand. Do you have a security clearance? No, I do not. Okay, that's been established now. A classified map related to a military operation, and told the representative that he should not be showing it to the representative and that the representative should not get too close. All right, so let's pull this evidence apart. We've got this piece, a military operation. So we actually have a document, a map. When we call this person to testify, the questions would be, do you have security clearance? No, I do not. Did the defendant show you any information? Yes, he did. And is this what he showed you? Yes, it is. And could you state what this is for the record? It's a map with the word classified on it. That kind of testimony is how you would get that admitted into court. Now, of course, this document is not something that would be made public, but it is something that could be submitted to the jury. Good luck with all of that. Zero evidence. Well, we're going through the evidence right now. That's exactly what we're doing. We're looking at the evidence. And this is the evidence. We have a man that Mr. Trump showed a classified map of a military operation to and said, don't get too close. So, that is the evidence. Map was in the code too. In what code? I'm not sure what code you mean. Yeah, this is the evidence. This is it. That's what we're going through right now. We're going through the evidence. Who's nervous? Who's nervous right now? The map might be hearsay. No, the map. All right, so I'm not going to spend too much time talking about hearsay because I find that people fall asleep quickly. But rules of evidence has the rule of hearsay involved in its Federal Rules of Evidence 801, 802, and 803. So take a look at that, and you can figure out whether or not this is hearsay. And then, we would debate that in court. If there's an objection to hearsay, which I'm sure his defense counsel would use because every good defense counsel is going to say that, then you're going to say, well, this is an exception. Now, the classified map itself, again, is something that you would just ask, like, here's the document. Now, also, if you take a minute and you think about if you're in the jury box, all right? So let's just imagine you are impartial, you're in the jury box. This person's testifying, I went to go hang out, I'm part of his political action committee, which means, that they are on good terms when he went there. And he showed me this map. Here's a picture of the map. So imagine this person or the government putting in as an exhibit this map that's got this term classified at the top of it. I'm wondering, how important that's going to be. Something too that I think it would be very interesting that if I was his defense counsel, what I would argue, honestly, is the actual visual representation of the map with the word classified on it. I don't know. I would argue that might be too prejudicial because even though it's relevant, the fact that these terms provide a visual for the jury, might prejudice the jury. They might emotionally appeal to that piece of evidence because of what's written on it. Would that objection fly? Probably not, but it's something you would want to raise if you're defense counsel. That is what we call a 403 objection. Okay, and I'll just show you the rule here. I won't spend too much time on it, but Rule 403, we can exclude relevant evidence for prejudice, confusion, waste of time, or other reasons. So if we felt that that showing, that visual representation of a classified document here would prejudice the jury, we could object to it as defense counsel. Drink water. Am I sounding a little rough? We are just taking and looking at the different pieces of evidence that are here in the indictment out of Florida. Yep. And I think I will take that suggestion and have a drink of water here quick. Okay, so there we go. We've got another piece of evidence here. We've got some arguments for and some arguments against, and how we would go about. But we know that we would present that evidence through the witness as an exhibit. Yes, hydrating is very important. Sometimes I spend a lot of my time talking throughout the day, so my voice gets a little, by the end of the day, I'm kind of in my, I'm off the clock now, so this is my off the clock voice. All right, so here we go. Let's look into some more pieces of evidence here. On March 30th of 2022, the Federal Bureau of Investigation opened a criminal investigation into the unlawful retention of classified documents at the Mar-a-Lago Club. A federal grand jury investigation began the next month. The grand jury issued a subpoena requiring Trump to turn over all documents with classification markings. Trump endeavored to obstruct the FBI and grand jury investigations and conceal his continued retention of classified documents by, among other things, and let's take a look at this evidence here that they've listed out. Now, keep in mind, too, that this obstruction code section that they're using is the same obstruction code section that has been used in some of the other cases involved here. All right, so first, suggesting that his attorney falsely represent to the FBI and grand jury that Trump did not have documents called for by the grand jury subpoena. All right, there's our first piece of evidence. How are we going to prove that he suggested to his attorney to falsely report this information? How are we going to prove that? Where would we find the evidence? No, ill will doesn't need to be found beyond a reasonable doubt, just the elements of the statute. This is the indictment. Yeah, the witness statement. This person, right? His attorney was asked by him to falsely represent the FBI. So how we would prove that is we would call in his testimony. We would call in this person and say, hey, what did the defendant say to you about the FBI and the grand jury? And they'll say, well, he told me to say this stuff. Now, the question is this hearsay? Well, it is hearsay, kind of, but it fits under an exception, which is called an admission. And if our defendants make admissions at any time, any statement against their own interest, that can be used in court. You can testify to that. So we've got him coming in, testifying to what was told to him by the defendant. Next, directing defendant Walty Nada to move boxes of documents and conceal them. Welcome, VC. Welcome. Thank you. To move boxes of documents to conceal them from Trump's attorney, the FBI, and the grand jury. Now, we've got a situation where we've got a co-defendant. So how are we going to prove what the co-defendant was asked to do? There can be several ways. Was somebody else involved? Did somebody else hear this information? Hearsay can be used in many different types of situations. There's lots of exceptions. There's over 27 exceptions. So if he was directed to make this move, the question can become, did someone listen to him make that direction? Or was there video surveillance of that? Can we see him directing the other co-defendant to move the boxes? So we can get this kind of information in as evidence without the co-defendant needing to testify. That is possible. Right. Attorney-client does not apply when there's a crime being committed. Absolutely. That's the number one way to break that privilege. And also to have somebody else present at the same time would also break the privilege. And that's the same for doctor-patient. All right, so there's our next piece of evidence. Here we go. Suggesting that his attorney hide or destroy documents called for by the grand jury subpoena. And again, how do we prove that? Well, we would need testimony from the witness. So, who are you? Well, I'm the attorney for the defendant. I'm his former attorney. And did he ask you certain things about the documents? Yes, he did. What did he ask you? Well, he asked me to hide and destroy documents. And what documents were they? They were the ones specifically written out in the grand jury subpoena, something like that, as an example of what kind of testimony would prove this piece of evidence here. So, and again, when we're just looking to probable cause, this is plenty. But if we're looking to proof beyond a reasonable doubt, we're going to need that attorney to come in and to testify to that. Next, providing to the FBI and grand jury just some of the documents called for by the grand jury subpoena while claiming that he was cooperating fully. So now who would we need to testify here? We're going to have someone from the FBI saying this is the kind of information we asked and this is what we received. So whoever was in charge of kind of collecting that evidence that came because of the subpoena would be able to testify to that. And also, you could, as a strategy, you could say, what documents were asked for? And he could go through, or she could go through and list the documents that were asked for, and then what documents were missing, and go through that kind of thing. Again, if I'm the defendant's counsel, I would probably object that this would be prejudicial. I would make a 403 objection. Would I win it? I don't know, but I probably would make that kind of an objection here. Also, probably cumulative evidence under 403 as well. So, yep. All right, next one. Causing a certification to be submitted to the FBI and grand jury falsely representing that all documents called for by the grand jury subpoena had been produced, well knowing that, in fact, not all such documents had been produced. So now we've got an element of intent that we need to prove. So first we have the certification. So we've got a document, a certification. We'll need an agent to come in that received that certification. And they'll go through what it means. And then when we need to go forward and say, did he know that it wasn't true, that they hadn't been produced, what would we need for evidence in order to prove that? What would be a key piece? Yes. We are innocent until proven guilty. Right. Awareness. And we would be able to prove awareness through maybe emails that he had with other people, text messages that were done with other people, multiple pieces of evidence that we may actually get into further into this indictment. Security camera, exactly. Yes. So to just actually physically put him in the same place where the boxes were and the papers were after he had signed that certification could also show. Right? Well, what are you looking at right here? Where we see you on camera standing in front of this, group of boxes that have the documents in it. Now, he, of course, could say, I didn't know what was in those boxes. Of course he could say that. But that would be one of the ways that we would prove that. Okay, so next piece of evidence was added. This is part of the superseding indictment. And throughout this indictment, whenever anything was added to make this the superseding, I will point that out. So this piece, letter F, was added July 27th. Attempting to delete security camera footage at the Mar-a-Lago Club to conceal information from the FBI and the grand jury. Now that's another piece. That's another element they're saying was involved. Now, before I get into how we would prove that, I do want to wait because we'll come down here just a few paragraphs down further and we'll talk about how they came to this charge, how they came to add this to this indictment. Yes. All right. So we'll come back to this. I'm going to leave a little cliffhanger here. We'll come back to the evidence, but this was what was added July 27th. Again, the superseding indictment just means that there were additional counts added, an additional defendant was added as well. As a result of Trump's retention of classified documents after his presidency and refusal to return them, hundreds of classified documents were not recovered by the United States government until 2022, as follows. Now we're looking specifically to the evidence that they're saying was illegally kept. On January 17th, nearly 1 year after Trump left office, and months of demands by the National Archives and Records Administration for Trump to provide all missing presidential records. Let's pause there. Now, what evidence do we have here in this part of the sentence? We've got months of demands by the National Archives. So what are we going to be looking for? Emails? We're going to be looking for phone calls. We're going to be looking for letters. What do we have to show that the archives actually made these demands of him? And then we will need a witness saying, I sent this letter on such and such date at such and such time, and he did not respond. So that's what we will need for the kind of evidence in order to prove that this actually happened. Like, we asked him multiple times. That will be who is sitting on the stand and testifying. So next, Trump provided only 15 boxes, which contained 197 documents with classification markings. Again, whoever the clerk was, whoever was in charge of going through and documenting all of these boxes would be called to the stand to testify to that. Next, on June 3rd, in a response to a grand jury subpoena demanding the production of all documents with classification markings, Trump's attorney provided to the FBI 38 more documents with classification markings. Again, we've got a witness. Call him up to the stand. What did you find? Well, I found 38 more documents that had classification markings. This is, of course, going to be the evidence showing that the documents were still in Mr. Trump's possession after they had requested and subpoenaed them. Right. So we've got two significant pieces of evidence here. We've got a batch of demands made by the National Archives. We've also got his attorney stating, I've got all these documents that I personally found with classification markings. Now, on August 8th, pursuant to a court-authorized search warrant, the FBI recovered from Trump's office and storage room at the Mar-a-Lago Club 102 more documents with classification markings. So now we will just need whoever the agent was, call him up to the stand or her and say, hey, how many more documents? Well, we found 102 more documents. And then strategically, the government could say, well, let's walk through each one of those. You know, Exhibit 102, what is this? And setting it out. Exhibit 103, what is that? And so on and so on. All of those documents could technically be argued to try to get into court. On the other side, they would object probably to every single one of them. But it's one of those things where you just need this agent to come in and just give those facts to the jury. Yep. What would the defendant need to say for all of this to be dropped? I plead to a lesser offense, maybe? Yep. Yeah, there's a lot. Pay the judge. No, we don't do that here. We don't do that. And the implication is really quite atrocious. We just don't do that. All right, Trump's co-conspirators. Defendant Nauta was a member of the United States Navy stationed as a valet in the White House during Trump's presidency. Beginning in August of 2021, Nauta became an executive assistant, and then this explains his role here. But what's new, what's been added to the superseding indictment has been this addition of information for our new third defendant, Carlos de Oliveira. Beginning in January of 2022, defendant de Oliveira was employed as a property manager at the Mar-a-Lago Club. Prior to holding the position of property manager, de Oliveira was employed as a valet at the Mar-a-Lago Club. So now we've got we would call this his foundation, the introduction to the court of who this particular person is. Now we go on to the next page and let's see what other evidence. And again, we're just looking here in order to look to the different pieces of evidence and to see if we've got probable cause or not. The Mar-a-Lago Club was located on South Ocean Boulevard in Palm Beach, Florida, and included Trump's residence, more than 25 guest rooms, 2 ballrooms, a spa, a gift store, exercise facilities, office space, and an outdoor pool and patio. As of January 2021, the Mar-a-Lago Club had hundreds of members and was staffed by more than 150 full-time, part-time, and temporary employees. Now, how would we prove this? We would just need whoever was in charge of his grounds, whoever was in charge of his home, to come in and testify. Can you set out the structure? This would also be probably traditionally what we would use a piece of demonstrative evidence for. Demonstrative evidence is evidence that's created just for the trial, just to help our jury understand something. So they could design a replica of his home in order to go through the different rooms and explain where everything was set out in order for the jury to have a better visual of how everything was set so that they have some idea of where everything was kept. So this would probably be a good opportunity for demonstrative evidence if it was to be used. Next, we've got between January of 2021 and August of 2022, the Mar-a-Lago Club hosted more than 150 social events, including weddings, movie premieres, and fundraisers that together drew tens of thousands of guests. And again, whoever organized these parties and various activities could be called to testify, whoever kept track of it, how many people were there, what kind of security was there, who checked who the guests were, who invited the guests, where all the guests were staying, where they were located, did they have access to all these different rooms. All of those kinds of things would be testified to. The United States Secret Service provided protection, a little heart, thank you, services to Trump and his family after he left office, including at the Mar-a-Lago Club, but it was not responsible for the protection of Trump's boxes or their contents. Again, we just need to have someone from the Secret Service come up and testify. Well, did you know about boxes and their contents? Nope, that wasn't part of our job. Trump did not inform the Secret Service that he was storing boxes containing classified documents at the Mar-a-Lago Club. The defense could probably come up and say, hey, is it required that he tell them that there were classified documents? Probably not. And so that would be their argument. Well, Trump didn't tell the Secret Service because there was no requirement that he did tell the Secret Service. That can be a bit of a double-edged sword, though, because then now we've got them saying he knew that there were classified documents, and he said he didn't need to tell the Secret Service about it. So there could be some problems with that kind of testimony. Yeah, there are a lot of trolls that come and visit, and that's okay. That's all right. They don't bother me one bit, one single bit. They don't bother me at all. So, I think somebody said once, "Don't feed the trolls," and I found that to be very helpful. Yeah, don't feed the trolls. Exactly. Yep, it's fine. It's fine. Okay, very good. Just checking in with everyone here. Oh, yes, you're welcome. Yes, it can be very frustrating, and I understand. All right, so we've got this question here of the Secret Service's role, and that kind of testimony, again, could go either way. Next, let's get into the classified information. Of course, anything here, this is all public record. This is the superseding indictment in Florida, so this is all public record. Well, hello from Wyoming. Well, hello. Welcome. National security information was information owned by, produced for, and under the control of the United States government. This would probably be one of those things where we would need someone to come in and talk to the jury and explain to the jury what a confidential document is and the process that we go through. So these kinds of things, you would bring in an expert. We would call them an expert, but someone who's specific to this kind of information and explain how it works. Pursuant to Executive Order 1295-8, signed on April 17th, 1995, as amended by Executive Order 13292 on March 25th of 2003, and Executive Order 13526. On December 29th of 2009, national security information was classified as 3 different categories: top secret, secret, or confidential. So let me just show you. Okay, so this is the law. If you're wondering, where did we come up with all of these different levels of classification? How does it work? This is what you're looking for. You will go and you will look for Executive Order 13.526. And within this, and I've got a post up on this document, but within this executive order, which was updated from 95 until most recently, they set out the rules for how to label classified documents. They also set out the rules for how to declassify documents. All those rules are set into place by this executive order on classified documents. Okay, so when we're talking about that in the indictment, this is the law we're referring to that is here, and it was updated last on December 29th. Now, all of the presidents can come in and update this and add their own bits and pieces to it. But President Trump, when he was president, did not add anything to it. So this is from Obama. So that's what we're talking about when we're talking about these executive orders. That's the law. So right here, they're going to go into explaining how the law is applicable here. Information was classified as top secret if the unauthorized disclosure of that information reasonably could be expected to cause exceptionally grave damage to national security that the original classification authority was able to identify or describe. Now, we have this language in here, reasonably could be expected to cause exceptionally grave damage. What does any of that mean? It's all set out in the law. It's all set out in this order. So they're summarizing it here in the indictment, but it's set out in this law, just in case you were wondering. So that's the level of top secret. Now, when we have the level of information classified as secret, if the unauthorized disclosure of that information reasonably could be expected to cause serious damage to the national security that the original classification authority was able to identify or describe. Again, specifically set out in that executive order and how we label our classified documents. And lastly, information was classified as confidential if the unauthorized disclosure of that information reasonably could be expected to cause damage to the national security that the original classification authority was able to identify or describe. So again, all of these categories are set out via the law that establish how we label our classified documents. The classification marking of no foreign, which was on the most recent count 32, added with this superseding indictment, stood for not releasable to foreign nationals and denoted that dissemination of that information was limited to the United States persons. So keep that in mind. Again, all of these definitions, all of these labels are set out by law. Classified information related to intelligence sources, methods, and analytical processes was designated as sensitive compartmented information, or SCI. SCI was to be processed, stored, used, or discussed in an accredited sensitive compartmented information facility. So any of this information had to be in a particular facility, and only individuals with the appropriate security clearance and additional SCI permissions were authorized to have access to such national security information. Again, this is all law. This is the law that is set out for classified documents. When the vulnerability of or threat to specific classified information was exceptional and the normal criteria for determining eligibility for access to classified information were insufficient to protect the information from unauthorized disclosure, the United States could establish a special access program. So what they're explaining here is, there were other means of going about looking at these records, and we could pull up this kind of a program that, again, is set out within that executive order in order to further protect the classified information. The number of these programs was to be kept to an absolute minimum and limited to the program in which the number of persons who ordinarily would have access would be reasonably small and commensurate with the object of providing enhanced protection for the information involved. So again, I take the time to go through this to explain this is the law regarding classified documents. We are not talking about presidential documents. That's a different law. This is classified documents. So let me just clarify one more time. The documents involved in this case fall under Executive Order 13526. All of these documents are under this law. If you want to look at the Presidential Records Act, that is this law, okay, and explains exactly what it is. And this is 44 USC Chapter 22. These records are different than the records that are set out in the executive order. So that's the key here to making that distinction between presidential records and classified documents. They're two different kinds. All right, so enough of that. Let's move on here. Pursuant to the Executive Order 13526, which I had just pulled up there, information classified at any level could be lawfully accessed only by persons determined by an appropriate United States government official to be eligible for access to classified information and who had signed an approved non-disclosure agreement. That's going to be incredibly easy to prove. So whoever is in charge of these non-disclosure agreements, call them up to the stand. Did Mr. Trump have one? No, he did not. Why didn't he? Well, because he wasn't given access. That's it. That's all you really need for testimony. Who received a security clearance and who had a need to know the classified information. After his presidency, Trump was not authorized to possess or retain classified documents. Again, this is after his presidency. He no longer had that access, and that can be proven by someone testifying. No, he does. He does. Everybody does. The president does, the vice president, the Supreme Court. It doesn't matter who you are. You have to have security clearance because the documents belong to the United States of America. They don't belong to a person. All right, Executive Order 13526 provided that a former president could obtain a waiver. So he did have a chance. He could have gone and gotten a waiver of the need to know requirement if the agency head or senior agency official of the agency that originated the classified information determined in writing access was consistent with the interests of national security and took the appropriate steps to protect classified information from unauthorized disclosure or compromise and ensured that the information was safeguarded in a manner consistent with the order. Trump did not obtain any such waiver after his presidency. So he could, but he did not. He could, but he didn't. So again, when we're looking at evidence, and the evidence is he had possession of classified documents, how do we know they were classified? Well, whoever was in charge of classifying those documents can testify this was classified. And then did he have authorization? Whoever gives out the authorization could testify. No, he didn't have authorization. So that's kind of it. And then we move next into the executive branch. Okay, let's hop on in. The executive branch departments and agencies whose classified documents Trump retained after his presidency. So now we get all kinds of different people that can come in and testify about these different documents in their department. And they can say, was this document classified? Yes, it was. Did your department have it? No, we didn't. The defendant took it and didn't give it back. I mean, again, I'm summarizing here, but that's the kind of testimony that we would need for evidence. As part, what's the timetable for presidents to turn over documents? Great question. And that's an excellent question. And I think it just depends. I think if the president's like, I got to go look at my closet and go through all my stuff. I didn't look through it. They're like, okay, fine. You got 2 weeks. Turn it over and that's fine. But the point is, at some point, you got to turn it over. So whatever time is needed, it seems like they're willing to work with them, at least based off of the past presidents that have taken documents home with them. They're like, hey, I need a couple weeks. And the archivist is like, sure, take your time. Just get them to me as soon as possible. And they do. But here the archivist is like, dude, we need our stuff. And he didn't give them their stuff back. Probably not. He probably shouldn't have left the White House, but leaving the White House with the documents is not what the problem was. The problem was he kept them. And when they asked for them back, he didn't give them back. That's really the key. So, several of our presidents have, taken documents with them. It's a crazy time and those kinds of things. But, yeah, I mean, they're like, dude, you have our stuff, give it back. And everybody gives back the documents except for this particular defendant. And that's why he's been charged. Willful retention. Yep, that's a good way to say it. All right, so as part of his official duties as president, Trump received intelligence briefings from high-level United States government officials, including briefings from the director of the Central Intelligence Agency, the chairman of the Joint Chiefs of Staff, senior White House officials, and a designated briefer. I have no idea who this person is, but he seems like he or she would be important. He regularly received a collection of classified intelligence from the United States intelligence community, known as, quote, the President's Daily Brief. This committee's mission was to collect, analyze, and deliver foreign intelligence and counterintelligence information to America's leaders, including the president, policymakers, law enforcement, and the military, so they could make sound decisions to protect the United States. The committee consisted of United States executive branch departments and agencies responsible for the conduct of foreign relations and the protection of national security. After his presidency, Trump retained classified documents originated by and implicating the equities of multiple committee members and other executive branch departments and agencies, including the following. So let's go through each of these. And again, each of these people can come and testify because it's their documents from their departments. The Central Intelligence Agency, the CIA, was responsible for providing intelligence on foreign countries and global issues to the president and other policymakers to help them make national security decisions. So before I dive too far into each of these different departments, yes, you're not stripped of your security clearance. It just expires when you leave office. So it's just like you walk through the door and it expires. But let me ask you this. How do you think they're planning to break up the documents? Because we've got 32 different individual documents. So my question, I'm just wondering, are they going to have someone from each of these different agencies in charge of a certain batch of the documents? I'm just wondering. That seems to me like that would be much more organized than just having, every single agency going through every single document. Like there's some documents that were the CIA's, and so they're going to testify to those batches. Some of them are from the Department of Defense, and so they're in charge of a certain set of documents. So it seems like if they assigned the documents to the separate departments, then just one after the next, they would be able to get through all 32 documents. It seems like. Yep. It seems like that would be like the best way to organize that if you're thinking of strategies for a jury. Yes, they have to get clearance and they have to follow, the statute is really specific about putting that kind of information in front of the jury. So they have to go through a certain process and certain restrictions that kind of are going to be just in place for the trial. And then those will go away once they're done. But yeah, that's a great question. Oh, sure. Yeah, it's a great question. But yeah, I mean, that would be my question. So each of these is going to have someone who's in charge of their classified documents. And, again, we've got 32 of them. So we're going to have documents that are from the National Security Agency, the National Geospatial Intelligence Agency, which seems very specific. Like they're going to have a couple of very specific documents, I would imagine. A combat support agency within the DoD. Yikes. These might be the people that are in charge of that map that we were talking about. So they may need to be the ones getting into, admitting that into court. Is this the map? Yes, it is. Okay. Can you explain what's going on in the map? We can't because it's secured, but you know what I'm saying. I think that would be a good strategy, I think, to present the evidence in a way that makes sense for the jury to be able to follow it. So we have all of these different agencies, again, all of their classified documents. So they will all most likely be needed to come in and testify to say that it's part of their agency. That document was created from their agency. It was at his arraignment in Florida. Well, that's interesting. Okay, that's interesting. Yes, yes, you can be granted security clearance. And again, it's all about, there's so much. If you want to talk about red tape, it will be red tape. But there's laws saying you can't, cross the red tape. And so that's really what happened here is we got tangled up. Good evening, Dawn. Welcome. Welcome. All right, so now we've got each of our different departments here. So let's look at our public statements on classified information. And as I've done before, I like to kind of take a look now that this First Amendment has been asked and talking about, if we've got a First Amendment statement versus some other kind of statement. So let's go through these. As a candidate for President of the United States, Trump made the following public statements, among others, about classified information. Now, I'm assuming that they're using these statements to show his knowledge and intent of the importance of classified information, is what I'm assuming that they're using this for. On August 18th of 2016, Trump stated, "In my administration, I'm going to enforce all laws concerning the protection of classified information. No one will be above the law." So if someone were to come in and testify to that, again, this could go to intent. If I was defense counsel, I would object for relevance. I would say, how is this relevant? I don't know how that objection would be ruled on, but that's what I would put in for that. On September 6th, Trump stated, "We also need to fight this battle by collecting intelligence and then protecting our classified secrets. We can't have someone in the Oval Office who doesn't understand the meaning of the word confidential or classified." If I was defense counsel again, I would say, I would have a couple of objections. First, I would say relevance. What's the relevance of this? We're proving the elements of the code sections here, and this isn't relevant. I would also say this could be prejudicial. This could have a negative connotation that the jury would be able to hear. So this would also, I would use a 403 objection, which when a 403 objection comes out in court, we all just take a moment to pause and get very frustrated. But, as defense counsel, it's a legitimate tool. So, I'm not sure how this would necessarily get in, but, it could. September 7th, Trump stated, "One of the first things we must do is to enforce all classification rules and to enforce all laws relating to the handling of classified information." So again, this could be shown again to go in to say he knows that there are classification rules, so he knows there are rules. So those rules need to be followed. So this kind of a statement could be helpful, I think. Now the question would be, how would we get this statement in? We're not sure where these statements came from. They're public statements. So we would need to go to the original source, which is our best evidence. So, if somebody just recorded this off of the television, that's not going to be the best evidence. We'll want to go back to the source. So whatever date, whatever time he made this statement, we'll have to go to that source and bring them up to the stand to testify to it. Yep. Yep. So, and I'm not sure, again, who this person would be, but that would be the best evidence, and that's under our authentication rules. Yep. Did he say it in a debate? He said it on live TV? Sure. So all you would need would be the manager of the TV situation or whoever was the director or whatever. And they could come in and testify to that statement. All right. So let's move on here. September 19th, we also need the best protection on classified information. Again, goes to this idea that he knows that classified information needs to be protected. So if he had classified information and did not protect it, it goes against his prior statement, which again could be used in court. November 3rd, Trump said service members are here in North Carolina have risked their lives to acquire classified intelligence to protect our country. Again, going to the importance of this kind of information. That goes to knowing. There's no concrete controversy. Well, I mean, legally, like, the documents were labeled classified. He took them. They told him to give them back. He didn't. And now he's been charged with not giving the documents back. So I don't see much of a controversy, but, I mean, everybody's entitled to their day in court. I'm not a fact finder. I'm not the jury. And it really is up to a jury to decide how it's going to be done. It seems, as far as criminal cases go, this is one of those where it's like, it doesn't matter what your intent was, really, other than that you knew you had classified documents, you didn't give them back. I mean, those elements are not necessarily difficult to prove, but yeah. Oh, and some are photocopied. Yeah, I mean, I don't know if that evidence comes out. That could also be another piece, but yeah, I mean, we just have, these are just basic elements. It's like, is ABC present? Yes. Is it present beyond a reasonable doubt? It seems like it, but we don't have the fact finder deciding, and we are all innocent until proven guilty beyond a reasonable doubt. So that's why we go to trial. It does seem so obvious, and it has for a long time. Well, legally, yes, it does. But, our system is, you are innocent until proven guilty beyond a reasonable doubt. And so, I'm not sure what kind of defense they're going to put on. It seems like some of their arguments have been, that he didn't have to declass, or he could have the records because he was president, like the Presidential Records Act. But that doesn't fit under the law at all. But I mean, I guess they could argue that, or that he didn't know that they were classified documents, but then we have all of this evidence saying he knew, and then, I don't know. It's going to be interesting to see what kind of a defense is put on in this case, because it seems like, it's just as simple as, did you have the document? Yes. Was it labeled classified? Yes. Did you give it back? No. I mean, that seems like the end of it. But again, it's easy to say, standing on the outside, looking at it, and kind of putting this into hypothetical situations. But you think he packed his own boxes? Oh my gosh, no. That's what the box packers do. That they're specifically hired or part of the world in order to take care of the boxes. Yes, his lawyers. My goodness, I really. I mean, this is it. This is. They're doing their job, making sure that we've got everything done properly, which again is how you're supposed to do it. Everybody deserves a fair trial, an impartial jury, proper searches done, proper evidence. Everything needs to be done properly. So hopefully everybody did everything. We will see. All right, next we've got July 26th, Trump issued the following statement about classified documents. And again, we're just going into intent here. He knows that classified documents are important. So this kind of information, of course, would be presented if it was to say, well, he didn't know that they were important. He didn't know that there were rules he had to follow. He just didn't know. Which, of course, is one of those classic arguments that a lot of people, when they're at kind of the top of the pyramid, tend to make those arguments. Well, I didn't know. I can think right now of a person in a very high position who was like, well, I asked around and they said it was fine, that I didn't have to disclose it. And so they're like, I didn't know. A lot of people make those arguments, but those arguments do not hold up in court because they don't have the substance. And that's just seen time and time again. So that argument, they're combating that by saying, well, look at these statements you made. You know that this is sensitive and important documents. Ignorance of the law is not a defense. It can sometimes mitigate, it can sometimes lessen your sentence, but not knowing the law, none of us, just because we don't know the law, we're still going to get charged with it. It's still something that we can get charged with. He shouldn't have been president. Well, we can't look too far much into the rearview mirror on that, because it kind of came and it went. It was what it was, and now we kind of gotta make sure everybody's doing what they need to do. He went to jail for Nixon. There were a lot of people that went to jail. A lot of people. Yes. Oh, a judge said that. Interesting. It's one of those classic phrases. We all, ignorance is no excuse for the law either, which I think is important. But They do. They do. They're cringe. So we're going to go on here. This is more of him acknowledging how important national security is. I won't take the time to reread through that, but we've got Trump's retention of classified documents after his presidency. On January of 2021, he was preparing to leave the White House. Trump and his White House staff, so we've got a whole bunch of people who can testify here, including Nada, packed items, including some of Trump's boxes. So anyone who packed a box could be called up to testify. Trump was personally involved in this process, so he was probably watching everything that was going on. Trump caused his boxes containing hundreds of classified documents to be transported from the White House to the Mar-a-Lago Club. Now, if I was defense counsel and I was arguing, one of the things I would say is this time was crazy. We had all kinds of crazy stuff going on. We had impeachment stuff going on. We were moving to Mar-a-Lago. We had to leave New York. We're not going back to New York. There's a bunch of stuff going on, so he couldn't have possibly have been able to keep track of all of the documents that were going into different boxes. And I think that would be, a good attempt for the defense. Is it a legal argument? Not really, because again, you don't have to say like, oh, I forced this document into this box because I knew it was classified and I wanted to keep it. Like, you don't have to go that far to prove the elements. But, how much do I get paid for this? Oh, I get paid nothing. This is all just for fun for me. This is pure fun. It's not the strongest defense, but I think it's, it's worth putting it forward. Yeah, who are they? Oh, yes, the transcript debacle. I think the debacle is to be put on the back burner, as I don't think it's going to be harmful. I think we'll have to figure out what happens, but... All right, so next we go from January through March 15th. Some of Trump's boxes were stored in the Mar-a-Lago Club's white and gold ballroom, in which events and gatherings took place. Trump's boxes were for a time stacked on the ballroom stage as depicted in the photograph below. Now this kind of an image, of course, will be in front of the jury. It's going to be pretty persuasive that this was the security level for these kinds of classified documents. I would say this would be pretty significant. Yes, there's still, yeah, nope, I'm not getting paid, although I'm thinking about doing some merch. That crossed my mind. I might make some purple pens that say, oh my goodness, I've been thinking about it. But we'll see. I don't know. I'm not confirmed. I'm just tossing it around. All right. On March of 2021, Nada and others. Oh, thank you. Merch. We'll see. Nada and others moved some of Trump's boxes from the white and gold ballroom to the business center at the Mar-a-Lago Club. Again, any of these people, we wouldn't need to call in the co-defendant. We would have any of these other people to come in and testify. Did you move boxes? Yes. Is this you on the video moving the boxes? Yes, it is. That kind of testimony is perfectly acceptable. Or QR codes. Oh my goodness. All right. On April 5th of 2021, an employee of the office of Donald J. Trump texted another employee of that office to ask whether Trump's boxes could be moved out of the business center to make room for the staff to use it as an office. Trump employee 2 replied, quote, whoa, okay, so POTUS specifically asked Walt for those boxes to be in the business center because they are his papers. Later that day, Trump employee 1 and Trump employee 2 exchanged the following text message. All of this is going to be admissible in court. Of course, these employees would be called in to testify, and then they would be asked, did you guys text? Yes, we did. What was the meaning of the text? What did we text for? So we can definitely make it work if we move his papers into the lake room. Again, talking about the security of these papers. There's still a little room in the shower where his other stuff is. It's only his papers he cares about. There's some other stuff in there that are not papers. Could that go to storage, or does he want everything in there on property? Next, yes, anything that's not the beautiful mind paper boxes can definitely go to storage. I'm not sure. I'm wondering who Trump employee 2 is. They seem funny to me. Want to take a look at the space and start moving tomorrow in the morning? So these guys will come in, or gals, whoever they are, will come in and testify to this message, these discussions that they had back and forth. After the text exchange between these two employees in April of 2021, some of Trump's boxes were moved from the business center to a bathroom and a shower in the Mar-a-Lago Club Lakes room, as depicted in the photograph below. I'm wondering too, again, just thinking trial strategies, this would be a great way of putting some more demonstrative evidence together to kind of have this layout of the house, and then with these pictures kind of like moving throughout the house. I mean, I'm just thinking trial strategies, because we're literally following the evidence. We're tracing the evidence from the White House to these different rooms and then to various other places. And to make a demonstrative piece of evidence that shows the movement, I think would be helpful for the jury to understand. Just as an idea. Yes, that was a mistake in the transcript. I was wondering. Yes, the boxes were all numbered. Exactly. And I mean, just imagine if you see a display of the house, from the top or whatever, and you see the pictures of the boxes moving everywhere, I mean, that could show you how the boxes were treated, how they were moved around, and so on, and that they weren't secure. I'm just spitballing ideas here. I'm just spitballing. I don't know. I don't know which number employee he was. I did not pay attention to that. Boxes peeking out behind the shower curtain. Yes. We need to be careful. We don't want to be too prejudicial here, but I mean, this photograph is what it is. I mean, it just kind of speaks for itself with what's going on with that. So, Melania. Oh, poor Melania. I don't think so. Oh, my goodness. Oh, secret documents. Yes, it was. Oh, the chandelier. Yeah, I think we all have thoughts about this picture. I mean, no matter who you are, I think we all have thoughts about it. I mean, this is a bathroom, and, I'm trying not to be judgmental, but it looks like a pretty posh bathroom. So maybe it was secure. I mean, maybe it was secure because of that. How do the attorneys explain that? They don't at this point. The only thing I have heard anything about from his attorneys has just been, he had the authority to have the documents, which, is a double-edged sword, because they're admitting the documents were classified. They're just saying, well, so what? We still had permission to have them. We had that authority. So I don't know. I think there's a lot more going on. At least I hope so. All right. In May of 2021, Trump directed that a storage room on the ground floor of the Mar-a-Lago Club be cleaned out so that it could be used to store his boxes. The hallway leading to the storage room could be reached from multiple outside entrances. Again, this would be perfect for demonstrative evidence, to just show the hallway with all the different entry places, including one accessible from the Mar-a-Lago Club pool patio through a doorway that was often kept open. The storage room was near the liquor supply closet, linen room, lock shop, and various other rooms. Okay. On June 24th, Trump's boxes that were in the lake room were moved to the storage room. But you see how that would be interesting if you just walk the boxes along to the storage room? I think that could be helpful visually. After the move, there were more than 80 boxes in the storage room, as depicted in the paragraphs below. And these photographs, I think, are also very helpful to kind of illustrate, again, somewhere amongst these boxes, and again, we're looking at 32 specific documents. There are 32 documents here that he has been charged with. So somewhere amongst all of this are going to be the documents. So it's going to be a matter of saying, according to what we found, this box had document number, 26. And then we'll go in and explain, what is document 26? Is it classified? Yes. Was it in this box? Yes. And then all the people to support that it was in the box. It's not a crime. It's a crime. Yeah. No, it is a crime. You can't have classified documents unless you have clearance. I mean, that's the crime. You can get clearance, but if you don't have it, you can't have the document. Where's Joe's documents? I got no idea. But, he's not been charged with anything. I think if he gets charged, we probably would have more information to go through. Yes, you can. when you're the president, you can. He was no longer the president. He was not the president at the time that this occurred. That's really a key takeaway. I mean, once he was no longer president, his security clearance expired. He was done. And so any clearance that he had was gone. And he, took them, and they took them all the way around to various places. Why do you think... Oh, wait, hold on. Why do you think he was not charged? I'm not sure what you mean. I think it just takes time to put a case together. Yeah, I think a lot of people are struggling. It's hard to kind of wrap your mind around it. Like for me, I'm trying to think of it both ways. I'm trying to think, what objections would defense counsel state to this? And, I'm struggling with it. I'm, like he didn't know what was here. But again, knowledge is not necessarily key. He knew that there could be, and that would be the kind of questioning. Is it possible that there were classified documents? Yes, there were. I mean, the fact that the possibility is even there could be used in front of a jury. Yes, true. Yeah. Well, I don't know about the G. We try not to say the G word here. Ooh, goodness. All right, moving on. December 7th, Nada found several of Trump's boxes fallen and their contents spilled onto the floor of the storage room, including a document marked Secret Rel to USA FVEY, which denoted information in the documents was released only to the Five Eyes Intelligence Alliance. Consisting of these countries, he texted Trump employee 2, quote, "I opened the door and found this." Now, this is a gift. As prosecutors, when we see stuff like this is like, thank you, happy holidays. When you have a gift of evidence like this, because and we're not going to, but if you look close enough and analyze this, you're going to be able to find the documents that we're talking about here. All of that is going to be able to be blown up as large as possible and put in front of the jury in order for the jury to see what's going on there. So this photograph evidence is pretty huge. Right. One of the photographs Nada texted to Trump employee 2 is depicted below, with the visible classified information redacted. Trump's unlawful retention of this document is charged on count 8 of the superseding indictment. So they even picked out which document. Again, each count is for an individual document. So document number 8 is somewhere in here, and they'll be able to show that to the jury. They'll be able to say, hey, look, he's got possession of document 8, which was classified. So that's going to be their evidence there. Next, we've got Trump's disclosure of classified information in private meetings. On May 2021, Trump caused some of his boxes to be brought to his summer residence at the Bedminster Club. Like the Mar-a-Lago Club after Trump's presidency, the Bedminster Club was not an authorized location for the storage, possession, review, display, or discussion of classified documents. Again, they're just establishing this location was also not supposed to be used under the rules for classified documents. When he was no longer president, again, that's the key because he didn't have security clearance anymore, Trump gave an interview in his office at the Bedminster Club to a writer and a publisher. We've got more witnesses in connection with a then forthcoming book. 2 members of Trump's staff also attended, so we've got 2 more witnesses here, which was recorded with Trump's knowledge and consent. Before the interview, the media had published reports that at the end of Trump's term as president, a senior military official, this person purportedly feared that Trump might order this on a country. Trying to be careful, tiptoeing here, and that the senior military official advised Trump against doing it. So this is an important document, right? They're just going to need to have someone come in and testify to that. Yes, a lot of witnesses. Upon greeting the writer, publisher, and his 2 staff members, so we've got 4 people, Trump stated, "Look what I found. This was this official's plan. Read it and just show it's interesting." So he's telling them to read it, and that's interesting. Later in the interview, Trump engaged in the following exchange, which of course was all recorded. So all of that evidence would be presented to the jury. Well, with this person's, let me see that. I'll show you an example. He said that I wanted to attack this place. Isn't it amazing? I have a big pile of papers. This thing just came up. Look, this was him. They presented me this. This is off the record, which nothing's off the record ever again. but they presented me this. This was him. This is the Defense Department in him. Writer, wow. I can respect that. It's short. It's to the point. Trump, we looked at some. This was him. This wasn't done by me. This was him. All sorts of stuff. Pages long and look. Wait a minute. Let's see here. Laughter. Yeah. I just found, isn't that amazing? This totally wins my case, you know. So fascinating. All recorded. All can be testified to by the people that were present at the time. So now, yes, there was a recording of it, wasn't there? Yep. I'm wondering if you think, again, if you were sitting on the jury, what would be more effective for you, to listen to the recording or to have someone actually go through the lines of what was said? I'm wondering, because if you actually have the person who was there saying the lines, I'm wondering if that would have more of an influence on the jury or not. I'm just wondering. The recording? Yeah, listening to it, actually hearing the words. Yeah, I think that, that's pretty, both of them. Oh, sure. Yeah, why not? Why not go all avenues? So listening to it and then having the actual people involved reading the actual words that they used. Yeah, that's going to be pretty significant information. Again, this idea that he's sharing that, which is a violation of that code section that he was charged with, right? So let me just refresh everyone's memory here so that you know I'm not just making it up myself, right? Is willfully communicating the information to, or causes to be communicated to someone who does not have authorization. That's part of the code section that we're charging here. Listen with subtitles. Well, there you go. Then you get the best of all worlds. So then we continue to go through what he's going back and forth on. He knows he can declassify it, apparently, but he didn't. See, as president, I could have declassified it. Again, noting he knows it's classified and he knows he's no longer president and can't declassify it. And then we have this kind of laughter here. I can't, but this is still a secret. So acknowledging the content of what's in it. So he's saying, I can have whatever documents I want. I'm just thinking of what their defense would be. I can have whatever documents I want. I'm the president. But here he's even implying he knows that it's secret information, that it's off the record. So I think this testimony will be pretty significant when it comes to it. So at the time of this exchange, the writer, the publisher, and Trump's 2 staff members, so we got 4 people again, they did not have security clearances or any need to know classification information about a plan of attack on this country they were talking about. And again, that's very easy. Do you have security clearance? No, I do not. Or whoever's in charge of the security clearance. Whenever they get up to testify, does this person have security clearance? No. Does this one? No. Does this one? No. So then when they get up and testify, were you here when we asked so-and-so if you had security clearance? Yes, I was. And were they correct that you do not? That's correct. I do not have security clearance. That's how that testimony would probably flow. The document that Trump possessed and showed on July 21st is charged as count 32 in this superseding indictment. So this is that additional piece that was added on to this indictment, that last document. In August or September, when he was no longer president, which again is the key for security clearance, Trump met in his office of Bedminster Club with a representative of his political action committee. During the meeting, Trump commented that an ongoing military operation in Country B was not going well. Trump showed the PAC representative a classified map of Country B. And we've already talked about this before, but now we've got more details. And told the PAC representative that he should not be showing the map to the representative and to not get too close. Again, you can imply, why would someone ask you to step away from a piece of paper? The implication is, because the paper is sensitive, and so that goes to show the intent. If it's fine to just share this information because he could declassify it or he could have it because of his status, why would he ask someone to step away from it then and not get too close? Maybe he was just joking? I don't know. We could argue that. We could argue he was just joking around. It was taken too seriously. The PAC representative did not have security clearance or any need to know classified information about the military operation. Again, we would just need this person then to come in and testify. On February 16th, 4 years before Trump's disclosures of classified information set forth above, Trump said the following at a press conference. The first thing I thought of when I heard about it is, how does the press get this information that's classified? How do they get it? You know why? Because it's an illegal process, and the press should be ashamed of themselves. But more importantly, the people that gave out the information to the press should be ashamed of themselves. Really ashamed. So my question now, and it's an honest question, is this relevant? Is this relevant to have someone testify about this statement he made at this press conference? Do we need someone to come in and testify that he said this? Is this helping to prove the truth of the matter? That's my question. I'm not sure. He said it, right? He did say it, but is it relevant? Right, roll the tape. It's relevant. Okay, well, establishing knowledge of guilt. Okay, sure. You don't think so? Yeah, I think it could be argued either way. I think both sides will have to argue this particular piece out. A lot of this seems kind of like open and shut, but this particular piece, I mean, I understand why they included it, but if they're going to put this in front of a jury, I'm really wondering what the relevance is, how this would help them to further their case to the jury. So, because it reveals his state of mind as well. Very true. That's true. That he didn't know. Okay. Shows he knows he's wrong. Okay. So this could go to that intent element that we're looking for, that we're trying to put together. Because it shows that it's illegal to show people without proper clearance. Okay. Another really good point. Yep, it does. Because he's recognizing that there's something wrong here. An emotional appeal to the jury. Right, and we don't want that, technically. I mean, technically, we do not want to be appealing to the jury. Although, of course, we're trained to do that. But, that's one of the biggest reasons why we object to testimony. Will the jury get clearance? I would assume so, yes, because they're going to need to see the documents. They may not get the full documents. They may have redactions on it, but they're going to need to see the marking that says, clearance or whatever. He's aware of the actions and the consequences. That's an excellent point, too, that actions do have consequences. So he's acknowledging that in this statement. This will be interesting. It'll be interesting to see how it's argued in front of the jury, if this will be able to come in or not. This may be something that if I was defense counsel, I'd put this in a motion in limine. I'd say, under paragraph 37 on page 17 of the indictment, there's a statement that we think is way too prejudicial, is irrelevant, and should be struck. And I would take care of this as a pretrial motion, just strategically, if you were trying to think of that from a defense point of view. Okay, Trump's production of 15 cardboard boxes to the National Archives and Records Administration. Beginning in May of 2021, the National Archives and Records Administration, NARA, which was responsible for archiving presidential records, repeatedly demanded that Trump turn over the presidential records that he had kept over his presidency. Again, these repeated demands all would be documented. So phone calls, letters, whatever way that they sent those demands out, they're going to have documentation of that. What does a motion in limine mean? Oh, sure. Let me talk about that real quick. A motion in limine is a pretrial motion that we use to say there's just certain evidence that the jury should not hear because it will affect the due process of the trial. So if it's too prejudicial, or if we think it's cumulative, or there's some kind of issue with it that we think would put an issue in front of the jury, we can request in a motion in limine that particular piece of evidence be excluded from being given to the jury. And this is decided before we go into trial. So there's certain things that are just kept off the table. Parties can stipulate to certain pieces to not be used. Like the government could say, fine, take it off. We don't care. We don't need it. Or you can argue it out, and during a hearing, the judge can set a hearing and both sides can argue, like the government can say this is essential, defense can say it's too prejudicial, and then they argue it out and the judge decides. But a motion in limine just means, again, for the defense, you can go through and say, this piece is just too much to put in front of the jury. It will hinder our ability to have a fair trial. And then the judge will decide that. So it's a key piece of trial procedure that we use before we go into a criminal trial. Hopefully I didn't go on too bad about that. Sometimes I get so excited about pretrial motions. It's really terrible. It's too exciting. Oh, don't get me started on a motion for a bill of particulars. Just don't get me started on it. All right. Okay. So here we go. Oh, my dorkiness. Here we go. On multiple occasions, beginning in June, Nara warned Trump through his representatives that if he did not comply, it would refer the matter of the missing records to the Department of Justice. Between November of 2021 and January of 2022, Nara and Trump Employee 2, at Trump's direction, brought boxes from the storage room to Trump's residence for Trump to review. On November 12th, Trump Employee 2 provided Trump a photograph of his boxes in the storage room by taping it to one of the boxes that Trump Employee 2 had placed in Trump's residence. Again, we're going to have all kinds of evidence showing where this was placed and what it looked like so that the jury can identify which box has which piece of paper in it. Trump Employee 2 provided Trump the photograph so that Trump could see how many of his boxes were stored in the storage room. The photograph shown below depicted a wall of the storage room against with which dozens of Trump's boxes were stacked. So again, this is another, gift essentially to the prosecutor to have a piece of evidence like this where you can literally see which count, we already know what happened to document number 8. So let's just say document 10, is in this box. And so we would just highlight this for the jury. This is the box that had count 10 document in it. And you can see it's not in a secured location that was required. So there's a lot of ways to kind of show the jury where the documents were. Yeah, all the way to the ceiling. That's a lot. I mean, but if you're in a place for 4 years, you're going to collect a lot of stuff. But, you don't want your stuff to be classified documents. Keep an eye on that. If we've learned nothing else, we've learned, make sure you don't have any classified documents with you when you're leaving, is what I would recommend to people, to the windows, to the walls. Okay. Oh my goodness. All right. On November 17th, Nada texted Trump Employee 2 about the photograph Trump Employee 2 had provided to Trump, stating, quote, he mentioned about a picture of the boxes. He wants me to see it. Trump Employee 2 replied, calling you shortly. Again, this is establishing the authenticity of this picture. And of course, everything has to be authenticated when we take it in front of our jury. On November 25th, Trump Employee 2 texted Nada about Trump's review of the contents of his boxes, asking, quote, has he mentioned boxes to you? I delivered some, but I think he may need more. Could you ask if he'd like more in Pine Hall? Pine Hall was an entry room in Trump's residence. Nada replied in 3 successive text messages, all of which can be admitted into court. Knocked out 2 boxes yesterday. They'd been working on it, and then showing the jury what this room looked like and where the boxes were located, I think would also be helpful. Just as a way of demonstrating to them, this is where it was. We don't have a vague idea. We can put this classified document in this box, in this room at this time. All of those pieces are helpful elements for that jury. On November 29th, Trump Employee 2 texted Nada asking, next, you are on the property, no rush. Could you help me bring 4 more boxes up? Nada replied, yes, of course. So again, we've got this co-defendant involved in the moving of these documents via certain boxes. They're going to, of course, have tapes, and those tapes are going to show specifically which boxes. On December 29th, Trump Employee 2 texted a Trump representative who was in contact with Nara. Box answer will be wrenched out of him today, promise. The next day, Trump Representative 1 replied in 2 successive text messages. Hey, just checking on the boxes. Would love to have a number to them today. Trump Employee 2 spoke to Trump and then responded a few hours later in 2 successive texts. 12 is his number. Again, we've got people who can testify to all of these things that have happened. On January 13th, Nada texted Trump Employee 2 about Trump's tracking of boxes, stating, quote, he's tracking the boxes, more to follow today on whether he wants to go through more today or tomorrow. Trump Employee 2 replied, thank you. So we've got more testimony here. On January 15th, Trump employee 2, Nada sent him or her 4 successive text messages. One thing he asked was for new covers for the boxes for Monday morning. Can we get new box covers before giving these to them on Monday? They have too much writing on them. I marked too much. Trump employee 2 replied, yes, I will get that. So let's pause again and look at this evidence that we have. Specific text messages between the people moving the boxes around and the requests from the defendant. So that's pretty significant information. And all of this will be testified to in court. And for a jury to say, to listen to this, I've written too much on the box covers, which again, the implication is he wants to know what's in the boxes, right? Can you explain to the crowd how long a president actually has to surrender the documents? It's going to depend, and it will depend on the archivist. And the archivist will say, hey, can I have my documents back? And then the president's like, okay, whichever former president, pick one, will say, fine, I'll get them to you in a couple weeks. And then they deliver them in a couple weeks. In this situation, they demanded over and over and over again, and none of them were given. So I think the time limit isn't specific, but I think the fact that they aren't given back at all is. So deadlines aren't even being discussed because the demands being made on the documents are being just outright refused. Yeah, I mean, it's not specified in the statute or in the law when it comes to classified documents or in the Classified Records Act. The days aren't specified. So it's going to be up to the archivist, and the rules the archivist has are really at their discretion. Oh, I hope they don't go to jail. I don't think anyone's been charged. I think that we've got 2 here that have been. Is there a chance for a deal? Always. There's always a chance. Always a chance for a deal. Yeah, he didn't have a skiff. Oh my goodness. Oh my gosh, the skiff request. Yes. He did. Yeah, they asked, and that's the thing, is if you work with NARA, they'll work with you, as all the prior presidents or vice presidents, because they're responsible they have to give all those records back also. They're covered by the rules as well. But if you refuse to work with NARA, then they're going to say, look, we're going to file charges, and that's what happened here. 5 years for... No, I mean, those aren't the deadlines. The deadlines are, will you work with me? The answer is yes. Okay, well, let's work together. Or will you work with me? The answer is no. Okay, well, we need our stuff back. So that's kind of how that worked. All right, so moving on. We got some more evidence here. Gathered 15 boxes from Trump's residence, loaded the boxes to Nada's car, took them to a commercial truck for delivery to NARA. Again, we're going to have evidence showing the actions of all of this occurring. When interviewed by the FBI on May of 2022 regarding the location and movement of the boxes before the production to NARA, Nada made false and misleading statements as set forth in count 38. Now, this count is specific to Mr. Nada. If you make false statements, you're going to get your own count. So Mr. Trump's got his own count, Mr. Nada's got his own count, Mr. De Oliveira. They have their own separate counts when it comes to false statements because they made different statements to different people. But here, within the superseding indictment, we've got falsely stating he was not aware of Trump's boxes being brought to Trump's residence for his review before Trump provided 15 boxes to NARA in January of 2022. Now, how would we prove that? Probably they're putting him in a location where you can see him next to the boxes, is what I would assume. Again, I'm just assuming. Falsely stating that he did not know how the boxes that he and Trump employee 2 brought from Trump's residence to the commercial truck for delivery to NARA on January 17th had gotten to the residence. And when asked whether he knew where Trump's boxes had been stored before they were in Trump's residence and whether they had been in a secure or locked location, Nada falsely responded, I wish I could tell you. I don't know. I honestly just don't know. Again, because we've got direct quotes here, that would lead you to believe that we've got some kind of a recording or some way of knowing that these are the exact words that were used. Why doesn't the Presidential Records Act apply? Well, sure. Let me break it down for you, and we'll just do this quick and dirty here because I think it's important. Presidential Records Act covers these. Oh, thank you, putting a hat on the indictment. Covers these kinds of records. So, presidential records, management and custody of presidential records, restrictions, presidential records, and so on. All of these kinds of records are set out and defined as presidential records. They're included in here. Those are presidential records. Now, classified documents are set out according to this law, the Executive Order 1352-6. So in order to have something labeled as classified, it falls under the category specified in this particular law. So this one sets out what do we label it? How are they kept? How do you declassify it? Who has clearance? Classified information may not be removed from official premises without proper authorization. All of the rules specific to anything labeled with classification on it is covered by this law here. If it's labeled classified, it is not a presidential record. Presidential record falls under a different set of laws. So that's why the Presidential Act doesn't apply. Presidential records are not what we're talking about when we're talking about clearly labeled classified documents. Now, it can be declassified and then become a presidential record, I suppose. But if it's labeled classified and it's active classified, then it's a classified document. That's how it works. That's just the executive order versus the other law. So it's just two different sets of laws. And these documents fell under the classified records. If there were presidential records, they would fall under the Presidential Records Act. But these are not those records. All right, so hopefully that was... Oh, I don't think we have any stupid questions. Just things you know about and things you don't know about. There's nothing wrong with that. What was in the boxes and why was it illegal and why did he have them? What was in the boxes was just all kinds of different papers and various bits and bobs he had collected over the years, but intermixed with that were classified documents that he, once his classification ran, when he no longer was president, those should have stayed with the government. That's how it was supposed to be. And so they didn't. And so NARA said, hey, let's talk about this. And Mr. Trump was like, no, I'm going to do it whatever way I want to do it. I'm not going to do it according to what you want. And so that's kind of what happened. Then they said, fine, we got to go to court because we need our stuff back. You have the best voice. Thank you. Oh, that's so sweet of you to say. Thank you. Thank you very much. Wait. That makes no sense. I'm not sure which part doesn't make sense. We got papers that are labeled classified. You're supposed to leave them with the government or give them back to the government when they ask. That's really it. Yep. All right. Here we go. 15 boxes. And then he made these statements to the FBI. Now, making false statements to the FBI, that in and of itself is its own discussion. That's its own code section, which is set out here, statements or entries generally. So if you make false statements to the FBI, you can be charged under this code section. It's federal law. So all of the false statement counts are covered under this section of the U.S. Code. Now we've got, when the 15 boxes that Trump had provided reached NARA on January of 2022, NARA reviewed the contents and determined that 14 of the boxes contained documents with classification markings. Specifically, as the FBI later determined, the boxes contained 197 documents with classification markings, of which 98 were marked secret, 30 were marked top secret, and the remainder were marked confidential. So just taking a minute to say, if it was labeled like this, it's because of the executive order. If it didn't have a label like this on it, it could be a presidential document, sure. But this label means the document was a classified document. So that's what they're saying. So they have all of these different documents that have these markings on it. On February 9th, NARA referred the discovery of classified documents in Trump's boxes to the Department of Justice for investigation. The FBI and the grand jury investigation. On March 30th of 2022, the FBI opened a criminal investigation. On April 26th of 2022, a federal grand jury opened an investigation. The defendant's concealment of the boxes. All right, let's kind of pick apart this evidence. Again, we're looking for probable cause and how this evidence can be used in court. Secret doesn't sound very official. That's true, it doesn't. And, they picked those three terms and what they meant, and they put it in the executive order. So that's just kind of how that worked. I think they could have called it anything. They could have labeled it potato. If under the statute it meant it's classified. It's just whatever they designated was the name. If it was put on the paper, it meant it was covered by the classified document. Executive order. Oh, Australia, welcome. Welcome. All right, here we go. On May 11th, the grand jury issued a subpoena to the office of Donald J. Trump requiring the production of all documents with classification markings in the possession, custody, or control of Trump or the office of Donald J. Trump. Two attorneys representing Trump, Trump Attorney 1 and Trump Attorney 2, informed Trump of the May 11th subpoena, and he authorized Trump Attorney 1 to accept service. So service of the subpoena was accepted. On May 22nd, Nada entered the storage room at 3:47 p.m. That's extremely specific, so we must have some evidence showing that exact timestamp, and left approximately 34 minutes later carrying one of Trump's boxes. On May 23rd, Trump met with Trump Attorney 1 and Trump Attorney 2 at the Mar-a-Lago Club to discuss the response to the May 11th subpoena. Trump Attorney 1 and Trump Attorney 2 told Trump that they needed to search for documents that would be responsive to the subpoena and provide a certification that there had been compliance with the subpoena. Trump, in sum and substance, made the following statements, among others, as memorialized by Trump Attorney 1. So I think we know who our witnesses here who can testify to all of these statements. Again, any statements against your own interest we call those admissions, and if you're a defendant, those admissions can be used against you in court. You don't have to just make them to police, any kind of statements against your own interests. I don't want anybody looking. I don't want anybody looking through my boxes. I really don't. I don't want you looking through my boxes. Well, what happens if we just don't respond at all or don't play ball with them? Wouldn't it be better if we just told them we don't have anything here? Well, look, isn't it better if there are no documents? So all of those statements can be testified to. While meeting with Trump Attorney 1 and Trump Attorney 2 on May 23rd, Trump, in sum and substance, told the following story as memorialized by Trump Attorney 1. Again, here's our witness. Attorney, he was great. He did a great job. You know what? He said that it was him. That he was the one who deleted all of her emails. That 30,000 emails, because they basically dealt with her scheduling and her going to the gym and her having beauty appointments. And he was great. And so she didn't get in any trouble because he said that he was the one who deleted them. Trump related the story more than once that day. So let's pause again. Can anyone tell me what's the relevance of this? Is this relevant for the jury to hear? If we are the government and we're presenting this to the jury and the defendant objects on relevance grounds, what would we say? How is this relevant to prove that the defendant committed the crime that they are charging him with? Hearsay. True, it's hearsay, although it's a statement by the defendant, so those are in a special category. Very specific. Yep. He's asking them to lie. Okay. Yeah, they're really living rent-free, aren't they? He was setting it up as well. I didn't do it. Okay. Shows motive. Sure. You didn't. It's okay if you didn't study. That's fine. It's okay. I won't take any points off. Criminal intent. Okay. That maybe they maybe lied. Okay. Looking for a scapegoat. Who is she? Well, I think destroying evidence. The other person didn't get into trouble. Deflection. Shows intent. Okay. Cohen says what's happened. Shows a different treatment. Sure, but I'm wondering, and I think those are all excellent suggestions. And I'm wondering, though, if he feels like because somebody else got this treatment, the special treatment that he thinks was given, then he is entitled to that special treatment? Is that kind of what that play is? I'm wondering. A pattern of behavior. Okay. Mens rea. Intent. Okay. Of course he does. Exactly. Okay. Because he's hinting that they should take the fall. Oh, okay. That's a whole nother way of looking at it. Exculpatory. All right. So maybe he's hinting that, she had someone go down for her. So maybe he can have someone go down for him, maybe. Or Hillary destroyed everything the FBI asked for. And so if she did, then why can't he maybe? Is that what the argument is? I'm just wondering. I think it's interesting on how they would be presenting this to the jury. What would they be asking the jury for with this kind of statement? Okay. And one of those showing legal intent. All right. It makes sense. He's wanting the attorneys to destroy the documents. Well, and that's, I think all of those are excellent points. I'm curious because I think one of his arguments that continues to go around and around is, why isn't anything being done to Hillary if she did something bad? But, in the legal system, it's like it doesn't matter what anybody else did. It only matters what you did. And our legal standards are our legal standards. And if someone wasn't charged, they weren't charged, but you were charged. So you have to deal with what happened to you, not with what happened to others. That's the legal piece of it that I struggle to kind of get my mind wrapped around. Like, why are we bringing up another person? They don't seem relevant to me. Okay. It's worse. Defense will say he was just complaining. Okay. Right, they never charged her. Yeah, I mean, if there had been a charge, it's irrelevant. Okay, sure. Criminal intent. All right, well, very, very good. Yeah, I'm just curious what people think about that. It's not relevant. Okay, yeah, I mean, I can see both sides. I can see there's a couple of different ways of looking at that. No equal justice. Well, that's true, but no equal justice is not something that you would use to argue in court. Can I ask about why they label country A and B if we know the countries from the tapes? I don't know the countries. I am only looking to the four corners of the document. So for me, I have no way of knowing what those countries are. And I think that's how they set it out. So anyone that's not gathering additional information, they wouldn't have that knowledge. And so I think that's another way of kind of protecting that information. Tapes were leaked. Yeah, anything that's been leaked like that or memos or whatever, I just don't pay attention to it if I'm really only looking at the court documents. Someone else destroyed documents. He knew about it. Knowledge, not a mistake. Okay. Oh, excellent point. Yep. It was a mistake. He had affirmative knowledge of it. He's asking someone to lie to impede another government process of recovering documents. Okay, yep, I can see that. I can see that argument as well. Good point. Well, right. I mean, allegedly. I haven't seen the documents, so I just go with what's here. I mean, we can say, but for me, I prefer to just, if it's in the court document, then I'll believe it. So moving on. Thank you so much for that. That was great insight. Right. Yeah, I mean, I think it's interesting. It's interesting. I think this is something else that would definitely be argued about. This would be a motion in limine to even halt it before it got in front of the jury. But, I'm not sure how they would address it. On May 23rd, Trump also confirmed his understanding with Trump Attorney 1 that Trump Attorney 1 would return to the Mar-a-Lago Club on June 2nd to search for any documents with classification markings to produce in response to the May 11th subpoena. Trump Attorney 1 made it clear to Trump that Trump Attorney 1 would conduct the search for responsive documents by looking through Trump's boxes that had been transported from the White House and remained in storage at the Mar-a-Lago Club. Trump indicated that he wanted to be at the Mar-a-Lago Club when Trump Attorney 1 returned to review his boxes on June 2nd, and that Trump would change his summer travel plans to do so. Trump told Trump Attorney 2 that Trump Attorney 2 did not need to be present for review of the boxes. All of this is going to come out through testimony. This is going to be direct testimony from the witnesses who were there and present. Now, we've got the next piece. After meeting with Trump Attorney 1 and Trump Attorney 2 on May 23rd, Trump delayed his departure from the Mar-a-Lago Club to the Bedminster Club for the summer so that he would be present at the Mar-a-Lago Club on June 2nd when Trump Attorney 1 returned to review the boxes. That information would be testified to and would show he's delaying his departure for a particular reason. So that could go again to his intent, what was needed for that. Yeah, and there could very well be video. I mean, they're going to have some kind of evidence to back it up. But between Trump's May 23rd meeting with Trump Attorney 1 and Trump Attorney 2 to discuss the May 11th subpoena and June 2nd when Trump Attorney 1 returned to the Mar-a-Lago Club to review the boxes in the storage room, Nada removed at Trump's direction, which again we would need to prove, a total of approximately 64 boxes from the storage room and brought them to Trump's residence as set forth below. And again, this is where they're going to show which documents were moved to which places. On May 24th, between 5:30 p.m. and 5:38 p.m., Nada removed 3 boxes from the storage room. On May 30th at 9:08, Trump and Nada spoke on the phone for approximately 30 seconds. Between 10:08, and again, this implication here, because we have this kind of information, would be, do we have phone records then? Is that what we're thinking? Or do we have a video? I'm wondering about that. Because we could have subpoenaed phone records. It could be possible. Or we could have video of it. I'm not sure. Between 10:02 a.m. and 11:51 a.m., Nada removed a total of approximately 50 boxes from the storage room. On May 30th at 12:33 p.m., a Trump family member texted Nada, "Good afternoon, Walt. Happy Memorial Day. I saw you put boxes into POTUS room, just FYI, and I will tell him as well. Not sure how many he wants to take on Friday. On the plane, we will not have room for them. Plane will be full with luggage. Thank you." Now, of course, this kind of a text will be presented in front of the jury as well. They texted each other? Okay. Well, yeah. I was wondering about that. Nada replied, "Good afternoon, ma'am," smiley face emoji. "Thank you so much. I think he wanted to pick from them. I don't imagine him wanting to take the boxes. He told me to put them in the room and that he was going to talk to you about them." On June 1st, beginning at 12:52 p.m., Nada removed approximately 11 boxes from the storage room. On June 1st, Trump spoke with Trump Attorney 1 by phone, asked whether Trump Attorney 1 was coming to the Mar-a-Lago Club the next day, and for exactly what purpose. Trump Attorney 1 reminded Trump that Trump Attorney 1 was going to review the boxes that had been transported from the White House and remained in storage at the Mar-a-Lago Club. All of this is going to be testimony from Trump Attorney 1, is what I would assume. On June 2nd, the day that Trump Attorney 1 was scheduled to review Trump's boxes in the storage room, Trump spoke with Nada on the phone at 9:29 a.m. for approximately 24 seconds. Later that day, between 12:33 and 12:52, oh, thank you. Oh, my goodness, look at that. Nada and De Oliveira had moved approximately 30 boxes from Trump's residence to the storage room. So now we've got the addition of our third defendant. This is why we have a superseding indictment here to include our third defendant. In sum, between May 23rd and June 2nd, before Trump Attorney 1's review of Trump's boxes in the storage room, Nada, at Trump's direction, moved approximately 64 boxes from the storage room to Trump's residence, and Nada and De Oliveira brought to the storage room only approximately 30 boxes. So again, this is a lot of information following these documents in these boxes. And so we're going to be tracking each one of these 32 documents, what box they were in, when they were moved, and who moved them. So, right, Nada was his valet or his, personal assistant fella. And then De Oliveira was kind of like his grounds person. I think, and we've got a lot of boxes involved. All right, false certification to the FBI and the grand jury. Now, this is when you make false statements. You can get charged with that. So these are specific charges regarding Trump met with Trump Attorney 1 before Trump Attorney 1 conducted the review. Nada escorted Trump Attorney 1 to the storage room. Is Nada getting paid per box he moves by the hour? Oh, I wonder. That's a valid question. I think that's a valid question to ask. Oh my goodness. All right, between 3:53 and 6:23, Trump Attorney 1 reviewed the contents of Trump's boxes in the storage room. Trump Attorney 1 located 38 documents with classification markings inside the boxes. Was Trump Attorney 1 removed, placed in a Redwell folder. Now we're escalating here into the Redwell folder. This is their own set of documents. Trump Attorney 1 contacted Nada and asked him to bring clear duct tape to the storage room, which Nada did. Trump Attorney 1 used the clear duct tape to seal the folder with the documents with classification markings inside. So this is pretty significant here that the attorney noticed the significance of those documents. After Trump Attorney 1 finished sealing the folder containing the documents with classification markings that he had found inside Trump's boxes, Nada took Trump Attorney 1 to a dining room in the Mar-a-Lago Club to meet with Trump. After Trump Attorney 1 confirmed that he was finished with his search in the storage room, Trump asked, "Did you find anything? Is it bad or good?" Of course, this would all be testified to. Trump and Trump Attorney 1 then discussed what to do with the Redwell folder containing documents with classification markings and whether Trump Attorney 1 should bring them to his hotel room and put them in a safe there. During that conversation, Trump made a plucking motion as memorialized by Trump Attorney 1. Oh, poor Trump Attorney 1. He's going to have a lot of testimony. He's going to be testifying for days. He made a funny motion as though, well, okay, why don't you take them with you to your hotel room, and if there's anything really bad in there, like, pluck it out. And that was the motion that he made. He didn't say that. My goodness. All right, so that's all testimony. That can all be testified to. We contacted the Department of Justice, requested the FBI agent meet him at the Mar-a-Lago Club the next day so he could turn over the documents responsive to the subpoena. Also that evening, Trump Attorney 1 contacted another Trump attorney and asked her if she would come to the Mar-a-Lago Club the next morning to act as a custodian of the records and sign a certification. So this is what's in question here about this false certification regarding the search for documents with classification markings in response to the May 11th subpoena. Trump Attorney 3, who had no role in the review of Trump's boxes in the storage room, agreed. So this is why we've got that certification issue, because she was not involved in it, but she's the one that signed it. The next day, Trump Attorney 1's request, Trump Attorney 3 signed a certification of the custodian of records for the office of Donald J. Trump and took it to the Mar-a-Lago Club to provide it to the Department of Justice and FBI. In the certification, Trump Attorney 3, who performed no search, this is pretty significant, of Trump's boxes, had not reviewed the May 11th subpoena and had not reviewed the contents of the Redwell folder, stated among other things that, quote, based upon the information that had been provided to her, a diligent search was conducted of the boxes that were moved from the White House to Florida, which could be true. I mean, that's the information provided to her. She was told this. Also, the search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. Okay, she was probably told that also, and any and all responsive documents accompany this certification. So I don't know. This seems relatively not the strongest piece of the case. If she's saying based on the information provided to her, she agreed to this. That's pretty, yeah, she just signed it. This is pretty good legal language that we use quite a bit. Like, well, based off of what I knew, I just signed it. So that can be a little bit questionable. All right, these statements were false because, among other reasons, Trump had directed Nada to move boxes before Trump Attorney 1's June 2nd review, so that many of the boxes were not searched. Many documents responsive to the May 11th subpoena could not be found, and in fact were not found by Trump Attorney 1. So any information he had given to Trump Attorney 3 was not accurate. Shortly after Trump Attorney 3 executed the false certification on June 3rd, Trump Attorney 1 and Trump Attorney 3 met at the Mar-a-Lago Club with personnel from the Department of Justice and FBI. Now we're getting into this issue of false statements also. Trump Attorney 1, Trump Attorney 3 turned over the Redwell folder containing the documents with classification markings, as well as the false certification signed by Trump Attorney 3 as custodian of the record. Trump, who had delayed his departure from the Mar-a-Lago Club, joined Trump Attorney 1 and Trump Attorney 3 for some of the meeting. Trump claimed that the Department of Justice and FBI, that he was, quote, an open book. This is a very vague term. I'm not sure they can say, like, you lied by saying you're an open book. I'm not sure that would necessarily hold up in a court of law. Earlier that same day, Nara de Oliveira and others loaded several of Trump's boxes, along with other items, onto an aircraft that flew Trump and his family north for the summer. So now, this is the page where we start with the new pieces that were added. This is what makes this the superseding indictment, because all of this coming up with De Oliveira, this is all new information. This has all been added July 27th. So tomorrow is the arraignment for the superseding indictment. And this indictment then, this next bit, this is all new that was just added a couple weeks ago. On June 3rd of 2022, when FBI agents were at the Mar-a-Lago Club to collect the documents with classification markings from Trump Attorney 1 and Trump Attorney 3, the agents observed that there were surveillance cameras located near the storage room. So now we are introducing another level here. We're talking about the surveillance cameras. On June 22nd, the Department of Justice emailed an attorney for Trump's business organization a draft grand jury subpoena requiring the production of certain security camera footage from the Mar-a-Lago Club, including footage from the cameras on ground floor basement where the storage room was located. On June 23rd, Trump called De Oliveira, and they spoke for approximately 24 minutes. Now, that's a long amount of time to be talking to somebody on the phone. I'm just going to put that out there. I'm not trying to be prejudicial. I'm just saying that's a long period of time. On Friday, the Department of Justice emailed the attorney for Trump's business organization the final grand jury subpoena, which required the production of, quote, any and all surveillance records, videos, images, photographs, and or CCTV from internal cameras at certain locations at the Mar-a-Lago Club, including, quote, on ground floor basement, from January 10th until June 24th. That same day, on June 24th at 1:25 p.m., Trump Attorney 1 spoke with Trump by phone regarding the subpoena for the security camera footage. Again, this is our new piece that was added to the superseding indictment. At 3:44, Nada received a text message from a coworker, Trump Employee 3, indicating that Trump wanted to see Nada. Less than 2 hours later, Nada, who was scheduled to travel with Trump to Illinois the next day, changed his travel schedule, began to make arrangements to go to Palm Beach, Florida instead. All of this, again, can be testified to. Now, the relevance and so on, that will have to be established through another grounds. But Nada provided inconsistent explanations to colleagues for his sudden travel to Florida. At 7:14 p.m. on June 24th, he texted one person that he would not be traveling with Trump the next day because he had a family emergency and used shushing emojis. At 9:48 p.m. that night, he texted a Secret Service agent that he had to check on a family member in Florida, and after he arrived in Florida on June 25th, he texted the same Secret Service agent that he was in Florida working. So let me pause us here for a minute. So we've got this whole thing going on about what's he not going on the trip for, the shushing emoji, there's a family emergency, Secret Service has been told. So my question again is this relevant? Is it relevant that he changed his mind or that he didn't have a good reason for why he needed to go back there? Is it relevant to the case? Is it important to prove that these documents were moved around in certain ways? Do we need the jury to hear this? It is hearsay, true, but we do have lots of different kinds of hearsay that is allowable in court. So hearsay can be allowed. But yes, okay, so if this is important, why is it important? Why do we need to know that he was being kind of, shushing and uncertain about why he was going back? Why would that be important? I'm just curious, because he's being shady, so it goes to his credibility, sure. So whatever he has to say maybe is not necessarily reliable. It shows that he knew what he was doing was fishy. Okay, sure, it goes to his intent. Yeah. Cover up. Maybe stuff is made up. Hiding potentially illegal acts. Okay. Okay. No respect for the, okay. Yes, hearsay is allowed. And again, we've got this here that sets out all the exceptions. So it's just, one of those things that's a bit of a pain, but it is allowed. Legal doctrine, stare decisis and all of that. Testifying, code language. Interesting. Lied to Secret Service, establishing a pattern of behavior. Okay, interesting. Oh, I do. I do have the smartest guess. I'm so thankful. It's very interesting for me to learn and to think of things from a different perspective. I'm very thankful for that. Showing he was being directed to do these things. Okay, so that could be another piece of it when it comes to the. It's relevant to the timing of the subpoena. Okay, yes. Oh, I hadn't even considered that. Oh, that's a good point. That's a very good point. Mm-hmm. Yes. We're here to help, and I'm thankful for that. And I'm very thankful for that. Define hearsay for us. Hearsay is a statement made out of court, being offered in court to prove the truth of the matter asserted. It's messy. It's messy. It's Federal Rules of Evidence 801, 802, and 803. So it's a mess. I think last time I started talking about hearsay, I may have been getting booed for a long time. So I've learned I won't go into it too much. Oh, please elaborate on the good point. Yes. Yeah, no, I'm just wondering here why we're talking about this kind of behavior from Mr. Nada. His inconsistent explanations about why his travel is changing. He was not going to be traveling with Mr. Trump, the shushing emoji and what's going on. And so someone had said it was important because of the timing of the subpoena, which I think is a good point. I think that's a very good point. So, interesting. That's just just something he's stalling for more time. Perhaps. I think it's present sense impression. Sure. I think that could be used as an exception. Absolutely. Yeah. I mean, I think there's a lot of different ways. Nothing looks guilty. Nothing does look. Yeah. As soon as you put the emoji up, now I can see where you're coming from. Okay. Excellent. All great points. All right. So around the same time on June 24th that Nada was making his travel plans to go to Florida, Nada and De Oliveira contacted Trump employee 4, who was the director of information technology. So the IT guy at the Mar-a-Lago club as follows. 5:02 p.m., Nada sent text messages to Trump employee 4 asking, quote, "Hey bro, you around this weekend," end quote. At 5:05 p.m., Nada texted De Oliveira asking, "Hey bro, you working today?" De Oliveira responded, "Yes, I just left." Nada then called De Oliveira, and they spoke for approximately 2 minutes. At 5:09 p.m., Trump employee 4 texted a response to Nada, "I'm local, entertaining some family that came to visit. What's up?" Nada responded to Trump employee 4, "Okay, cool, no biggie, just wanted to see if you were around. Enjoy, bro." At 6:56, De Oliveira texted Trump employee 4, "Hey buddy, how are you? Walter called me early and said, and it was trying to get in touch with you. I guess he's coming down tomorrow. I guess needs you for something." Trump employee 4 responded, "He reached out, but he didn't say what he wanted. I told him I was local, but entertaining some family that came down from New York this weekend. He told me no worries." At 6:58, Trump employee 4 texted Nada, "Bro, if you need me, I can get away for a few. Just let me know." Nada responded, "Sounds good, thank you." So we've got this set of texts going back and forth. And again, I would ask, what's the relevance? Why do we need to know about these conversations between Nada, De Oliveira, and Trump employee 4? Why is this important at all? Why is it even put into the indictment? Yeah. I mean, I'm wondering why. Not as the gopher, right? And the IT guy. What happens if he becomes president again during court? Well, that's a great question, Brax. It's confusing. True. I think these were lies to establish a timeline. Scott, I think you nailed it. I think that's it. I think we're trying to put into place, where was Nada? Where was De Oliveira? Why were they needing to get together? We have extra documents. Well, maybe. I think we all know how I feel about toilet paper after 2020. Connection as a witness. True. Yep, because we're introducing him or her, whoever it is, into it as well. Wanted some files deleted. Yeah, to delete the footage. I think we're setting up that time frame to say he stayed in town, but why? Because he needed to get together with De Oliveira. But why did he need to get together with De Oliveira? And I think it's setting up the next pieces of evidence. You think the IT guy's a guy? You might be right. All right, on Saturday, let's see what happens next. I feel like this is kind of getting us ready here for a couple new pieces of information. On Saturday, June 25th, Nada traveled from Bedminster, New Jersey to Palm Beach. Prior to Nada's trip, De Oliveira told the valet at the Mar-a-Lago Club that Nada was coming down. De Oliveira asked Trump Employee 5 not to tell anyone that Nada was coming down, because Nada wanted the trip to remain secret. Again, that's a little hinky, isn't it? And why is it included in the indictment? There must be some reason for it. De Oliveira also told Trump Employee 5 that Nada wanted De Oliveira to talk to Trump Employee 4 to see, quote, how long camera footage was stored. So that's important. Again, we've got some inferences we can take from there. Shortly after arriving in Palm Beach on the evening of June 25th, Nada went to the Mar-a-Lago Club and met with De Oliveira at 5:46 p.m. At the Mar-a-Lago Club, Nada and De Oliveira went to the security booth where surveillance videos displayed on monitors, walked with a flashlight through the tunnel. Again, extremely specific information here. So the evidence that they must have in order to show this would be very specific. The tunnel where the storage room was located and observed and pointed out surveillance cameras. On Monday, June 27th at 9:48 a.m., De Oliveira walked to the IT office where Trump Employee 4 was working with another employee in the IT department. De Oliveira requested that Trump Employee 4 step away from the office so that De Oliveira and Trump Employee 4 could talk. Again, this is kind of suspicious. Is it beyond a reasonable doubt suspicious? I don't know, but we're kind of setting some things up here. At 9:49 a.m., Trump Employee 4 and De Oliveira left the area of the IT office together and walked through the basement tunnel. De Oliveira took Trump Employee 4 to a small room known as the audio closet near the white and gold ballroom. Once inside the audio closet, De Oliveira and Trump Employee 4 had the following exchange. All right, so let's see what's going on in this audio room, audio closet. It's not even a room, it's a closet. And that would be something that would be helpful for the jury to see as well. That could have some kind of influence on the kind of conversation that they were having. De Oliveira told Trump Employee 4 that the conversation should remain between the two of them. Now, let me just say, nothing good ever happens in a conversation that starts out like that. You have to be careful when you say that. Or this is off the record. All of those things can all be... That's never a good sign right there. I'm just saying in general, it's not a good sign. De Oliveira asked Trump Employee 4 how many days the server retained footage. Trump Employee 4 responded he believed it was approximately 45 days. De Oliveira told Trump Employee 4 that the boss wanted the server deleted. All right, that's not the best. And of course, we're going to be able to have testimony directly stating that. Trump Employee 4 responded that he would not know how to do that and that he did not believe he would have the rights to do that. Trump Employee 4 told De Oliveira that De Oliveira would have to reach out to another employee who was a supervisor of security for Trump's business organization. So the IT guy is saying, look, I don't have this kind of authority. Talk to security. De Oliveira then insisted to Trump Employee 4 that the boss wanted the server deleted and asked, what are we going to do? That also never ends up well for anybody. What are we going to do? Oh my goodness. That's not the best. It would be good merch. All right, I'll add it to the list of merch ideas. Oh, yeah, it looks like Trump employee 4 was like really trying to do his job and say, "Look, I don't this is hinky. I don't think this sounds right." Um, yes. Yeah. Exactly. Excellent point. Excellent point. If you're going to do that, you need to take that accountability. At 10:14, De Oliveira texted Nada, who was still in Florida. "Hey, buddy, are you working today?" De Oliveira then called Nada at 10:15 a.m., and they spoke for approximately 1 minute. Later that day at 1:06, Nada texted De Oliveira, who was at the Mar-a-Lago club. "On my way to you," between 1:31 p.m. and 1:50 p.m. Again, extremely detailed, which means we must have evidence to prove these timestamps. De Oliveira walked through the bushes on the northern edge of the Mar-a-Lago club property to meet with Nada on the adjacent property, then walked back to the IT office that he had visited that morning, and then walked again through the bushes. I think this would be another great moment for demonstrative evidence for the jury. Let's, set out the layout here between the club and the adjacent property, and let's walk these guys through it so we can see, like, where are you going? What are you doing? Because this is so detailed. It seems like there's a point that they must be trying to make with that, is what I would assume. So I think this would be good for demonstrative evidence. And then walked again through the bushes on the northern edge of the Mar-a-Lago club property to meet with Nada on the adjacent property. At 3:55, Trump called De Oliveira, and they spoke for approximately 3.5 minutes. This is where the superseding indictment pieces end, and we go back into that original indictment. So just to make a note of that. The superseding indictment, again, we added that 32nd count, we added that third defendant, and we added in that extra piece of evidence, the classified document, and so on. So there were just a few additions made to make it the superseding indictment. So we're back down into the regular indictment at this point. Court authorized search of the Mar-a-Lago club. So we've got the FBI and the grand jury. They've got surveillance video. All of that can come in, showing the movement of the boxes back and forth. Court authorized search warrant. Again, that can all be shared in court. During the execution of the warrant, the FBI seized 102 documents with classification markings on it. So, and again, I just pause here for a moment and I say, look, we've got 102 documents and we were charged with 32 here. So technically, and I'm not good at math, that's why I'm a lawyer, but we've got, what do we have here? We got 32 counts. So we have 70 more documents that were classified that have not been charged. Is that math right? I'm trying to do quick math. Math is tough. It's a difficult thing for me with the math. Yeah, okay, good. Thank you. I might check my math. So 70 documents that could be charged. That have not been charged yet. We still have 70 that technically violates the law. So we could have 70 more counts, possibly, when they're saying they've got 102 documents with classification markings. So they're breaking down the different kinds. So out of these 102, they've only charged 32 documents. Just interesting to note, just over 2 weeks. And as a quick side note too, if we've got 70 more documents, let's say we go forward and we're not found guilty in this particular case. I'm just saying hypothetically, if we're prosecuting a case and we've got 100 counts, we only charged 30 to start, we still have 70 back in the hopper that we haven't charged yet. We lose on those first 30 counts, we can come back and charge another 30 counts and then, another batch until we get to the point where we get a conviction. That is possible. I'm not saying that's what's going to happen, but if you're keeping 70 documents to the side, you're kind of keeping those for a rainy day. So depending on what happens, you can still charge it. Legally is how that can work. Just as kind of just an FYI for everyone. Just over 2 weeks after the FBI discovered classified documents in the storage room, Trump's office, Nada called Trump employee 5, said the words to the effect of, "Someone just wants to make sure Carlos is good." In response, Trump employee 5 told Nada and De Oliveira was loyal, that De Oliveira would not do anything to affect his relationship with Trump. That same day, at Nada's request, Trump Employee 5, confirmed in a Signal chat group with Nada and the PAC representative that De Oliveira was loyal. So now we've got this question, are we loyal? Yes, we're loyal. That same day, Trump called De Oliveira and told De Oliveira that Trump would get De Oliveira an attorney. All right, so now we've got the attorney offer. On the, yes, loyal. I mean, what is that? What is that saying? Is what illegal? Isn't that illegal by omission? I'm not sure what you mean. You'll have to be just a bit more specific. Not loyal to, right. Right. Maybe. Don't want to say the M word. Can this be admitted later as federal election crimes? I don't know how. I don't know how this would have an effect on any of the acts involved in that. Only need to get your employees an attorney when shady things are happening. Yeah, it's a good question. I mean, these people are doing his bidding. It's very weird. It is a little bit different. And coordinating with the PAC, excellent question. Why is the PAC involved? I think we all know why the PAC's involved, right? Because the PAC is paying for representation. I'm not just making that up. I think there's been some discussion about that. Each bullet point a charge. No. Nope. Each paragraph is numbered, setting out different facts, but the counts themselves are going to be coming up actually on the very, very next page. Yeah, and who funds the PAC? I mean, that's a good question, but I think the fact that the PAC representative was involved in this discussion of getting De Oliveira an attorney, I think it's an important moment to note. So now, because you're asking about the charges, let's go into that. We've got counts 1 through 32, and I'm not going to go through each and every single document here. I think we've all kind of gone through this, but we've got a violation of Code Section 793. So this is a document. And what they did was they set out one count per sheet. So they found, over 100, but they charged 32. The superseding indictment adds that 32nd. Originally, it was just 31. Yay, Citizens United. Oh, ouch. That hit hard, man. That hit real hard. Is jury nullification a thing? It can be. But it's rare, and it typically means the jury doesn't like the law that's being used. So here we've got all of the counts, and for each count, what they did was they set out the date that it was discovered, or the dates of how it traveled, what classification it was, so top secret or whatever, and then the date of the document. So none of this has any of that private, essential, key pieces of information, because we're trying to protect these documents. This isn't really for everyone to know. So when they're charging the count and they're using this kind of a date and this kind of a label, then we're going to be able to identify that document when we're presenting it to the jury. They will have to get some kind of clearance in order to have it set up into place so they can actually see these documents, but this is how they're organizing it. So each count is a specific document. All right, so we've got a top secret, and then again, this brief description, May 3rd, May 9th, an undated document with military stuff on it. The document number 4 is top secret, a May 6th document, top secret, June of 2020, with this kind of stuff involved in it. My goodness. Number 6, top secret, special handling, June 4th. Oh, yes. Thank you so much. You guys are always so fun. I'm so thankful to be able to chat with you. June 20th, secret, no foreign. October 21st, we've got secret, and then these kinds of labels set out. October 4th document, top secret, redacted. So it's even redacted on the count. That's how special this document is here. Undated, and then we're going to not go into further details on that. We have top secret for November of 2017. We have one that doesn't have a marking on it. This is an undated document concerning military contingency planning in the United States. Now, if there's no marking on it, okay, for number 11, I'm like, well, how do we know it's a classified document? There must be another way this is identified as a classified document, or of course, we would ask for this charge to be dismissed if we are the defendant. Yes, special handling is defined by law within the executive order. So they'll have to have someone come in and teach the jury and explain to the jury how it works. We've got this number 12. So 11 is a little questionable because we don't have the marking, but again, we could have information that's missing that they just didn't put into the indictment. 12, we've got a secret here, undated document, another top secret, undated document, labeled secret. Again, this is all clearly labeled on the documents for January of 2020. Secret, February 20th, 20. Secret again, December of 2019. Again, every single document is listed as a count. I mean, every single one that they chose to bring. There were 102, and so these are only 32. Top secret, 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 formally restricted. Top secret, secret, top secret again. Here we go. Top secret, top secret, top secret, top secret, top secret, top secret, top. And then the last one, this is the new one that was added, which is document 32. Top secret, presentation concerning military activity in a foreign country. Again, I think we can all kind of wonder what document that was just added. But that was the number 32 document. So for each count, when you're hearing, always count, he was charged 32 counts. He was charged per document. So we had 102 documents. He was charged with 32. So that can kind of give you some idea of what the parameters are. Are we still quietly walking through the bushes? I can respect that. All right, so those were counts 1 through 32. Again, that 32nd count was just added as part of the superseding. Count 33, conspiracy to obstruct justice. This section should look familiar if you were with me for the DC indictment. We added on Carlos de Oliveira. He's been added into the co-conspirators because of the superseding one. And we have a new section that was added. And the section is 1512B2B, which is, and to corruptly alter, destroy, mutilate, and conceal a record, document, and other object from an official proceeding in violation of 1512C1. So this is with regards to the security footage. And that's where this new code section came in. Next, we've got the purpose. The purpose of the conspiracy was for Trump to keep classified documents he had taken with him from the White House and to hide and conceal them from a federal grand jury. That's the purpose. We always have to set out the purpose when we have an inchoate offense. The manner and means by which the defendant sought to accomplish the objects and purpose of the conspiracy included, among other things, the following. And again, we go through each one of these pieces, which, we've already talked about before. We've got the suggestions made to Trump Attorney 1, moving the boxes of documents around, suggesting that hiding or destroying documents, saying that we already gave everything to the FBI and the grand jury, but not actually doing it, a false certification by Trump Attorney 3, making false misleading statements to the FBI, and then we added this new piece here to the superseding, attempting to delete security camera footage from the Mar-a-Lago Club to conceal the footage from the FBI and the grand jury. So that's our new piece that was added to the superseding indictment. And again, the superseding indictment arraignment is tomorrow. Withholding a document or record, we've got, these are the same original count that it was in the original indictment. Knowingly engage in misleading conduct towards another person, knowingly corruptly attempt to persuade another person with the intent to cause or induce any person to withhold a record. So this is keeping the records, hiding and concealing the documents from the federal grand jury, and misleading Trump Attorney 1 by moving the boxes that contain documents with classification markings. So Trump Attorney 1 would not find the documents and produce them for the grand jury. Those were all included then in count 34. Here's count 35, corruptly concealing a document or record. Again, this is all from the original indictment. and count 36, which is also from the original indictment. Did someone say water? I think I will get a drink of water. You guys are looking after me. Thank you. Okay, so count 36, concealing a document in a federal investigation. Again, this language is what is in the original indictment. Yes, hydration is very important. All right. Trump and Nada hid, concealed, and covered up from the FBI Trump's continued possession of documents with classification markings at the Mar-a-Lago Club, and Trump caused a false certification to be submitted to the FBI. These are the two pieces that they're saying support this section of the code. Scheme to conceal, count 37, again, part of the original indictment, where we've got during a federal grand jury investigation, a federal criminal investigation being conducted by the FBI, Trump and Nada hid and concealed from the grand jury and FBI Trump's continued possession of documents with classification markings. And 38, false statements and representations. Now, each of them has their own count specific to them regarding the statements they made. So this is Mr. Trump's statements. The statements they are saying were false, and thus charging him under 1001A2. A diligent search was conducted of the boxes that were moved from the White House to Florida. So they're saying that was a false statement. Next, this search was conducted after receipt of the subpoena in order to locate any and all documents that were responsive to the subpoena. They're saying that that is false, that he said that and it was incorrect. And any and all responsive documents accompany this certification. So that's a certification element. So this is Mr. Trump being charged only here for count 38 for his false statements. That then takes us to our next defendant, Mr. Nada. He's got his own count 39, for his false statements. His false statements were to the FBI, and they're very particular. They said there was an interview that was going on with the FBI. He knew it was recorded. So here's what he said. The question from the FBI, are you aware of any boxes being brought to his home, his suite? Answer, no. So right off the bat, they're asking, do you know about any of the boxes? And he says, no. All right, so to the best of your knowledge, you're saying that those boxes that you brought onto the truck, first time you ever laid eyes on them, was just the day when Trump Employee 2 needed you, correct? To take them, okay. And knowing that we're trying to track the life of these boxes and where they could have been kept and stored and all kinds of stuff, do you have any information that could help us understand, like where they were kept, how they were kept, were they secured, were they locked? Something that makes the intelligence community feel better about these things, you know? Answer, I wish I could tell you. I don't know. I honestly just don't know. Whew. So those are a lot of statements that he's given to the FBI here. And what? So you only saw the 17 boxes. The day of the move, even they just showed up that day. They were in Pine Hall. Trump Employee 2 just asked me, hey, can we move some boxes? Okay. And I was like, okay. So you didn't know, you had no idea they got there before. Answer, no. So this is Mr. Nada's false statements that he is being accused of. The underscored statements and representations above were false, as Nada knew because, one, Nada did in fact know that the boxes in Pine Hall had come from the storage rooms. And how would we prove that? Probably through all of the communication between the different people. As Nada himself, with the assistance of Trump Employee 2, had moved the boxes from the storage room to Pine Hall, and 2, Nada had observed the boxes in and moved them to various locations at the Mar-a-Lago Club. So these are the false statements that are charged for Mr. Nada. Next, we have our new charges added on to the superseding indictment, count 40, which is altering, destroying, mutilating, or concealing an object. This specifically goes to requesting Trump Employee 4 to delete security camera footage at the Mar-a-Lago Club to prevent the footage from being provided to a federal grand jury. So that's count 40. All three have been charged with that one. Next, we have count 40, corruptly altering, destroying, mutilating, or concealing a document, record, or other object. All three again have been charged, and they're saying these three requested that Trump employ 4 delete security camera footage at the Mar-a-Lago club to prevent the footage from being provided to a federal grand jury. That's where we have the corruptly element to that. So count 41. And then count 42 is specific to Mr. De Oliveira. These are his false statements and representations that he has been charged with. So this is his discussion with the FBI. When, after the end of the presidency, boxes arrived to Mar-a-Lago, were you part of any group to help? Answer, no. Unload them and move them then. Answer, no. Do you even know, like, or were you even there or aware that boxes were? Answer, no. Like all this stuff was being moved in? Never saw anything. Okay, yeah, and then even his personal stuff, like his clothes? Never. And furniture? Nothing? Never saw nothing. Okay, so you don't know where items would have been stored as soon as he moved back to Mar-a-Lago? No. That's pretty clear. That's some pretty clear testimony there from Mr. De Oliveira that was recorded. The underscored statements and representations above were false, as De Oliveira knew because De Oliveira had personally observed and helped move Trump's boxes when they arrived at the Mar-a-Lago Club in January of 2021. All right, that takes us then. Oh my goodness. Oh, all of you have been with me for so long. Thank you so much. That takes us then into the counts, and we will go through the penalty sheets here. Let me just make sure I've got these in the right order. So I've got 57. We have 54. Hold on. Uh-oh. I'm missing a page. All right, one moment, please. Okay, so the very final documents here that are part of the indictment, I will take you through. These are the penalty sheets that were added on. So we've got first, this is just a regular for the clerk of court. So here's our penalty sheet. So we've got counts 1 through 31. And again, this is from the original one. Sorry about that. I've got to renumber this just a little bit. But I've got 1 through 32 when it comes to willful retention of national defense information. All of those we're looking at 10 years each. Now we've got count 33, which got changed because of the superseding indictment. And then this is now count 34 because of the superseding indictment as well, which takes us then to count 35 here. Corruptly concealing, count 36. Concealing a document in a federal investigation. This one's 37. This one's 38. And let me just make sure here. I've got Mr. Nada included. Let me get you a clean copy here. This is Mr. De Oliveira's. Mr. Nada. So these are the last, this is the corrected additional counts here. Sorry about that, little paperwork crunch. So count 40, again, this was part of the new superseding indictment for Mr. Trump, includes the altering, destroying, mutilating, or concealing of an object. We're looking at up to 20 years. And then count 41, corruptly altering, destroying, and so on. That's up to 20 years as well. And then we go to Mr. Nada. He's got count 33, 34, 35, which are all original to that first indictment, as well as 36. But now We have the addition of count 40 and 41, which has to do with the security tape. So those were additions to what he had had before. And then we have our brand new defendant, Mr. Carlos de Oliveira. He's got count 33, conspiracy to obstruct, count 40 and 41, which has to do with that destroying of the evidence, and false statements and representations for 42. So that takes us then to the very last page involving Mr. de Oliveira. So that is the entire indictment, the entire superseding indictment that the arraignment is set for tomorrow. Let me get myself organized here. I've just been throwing papers down like I'm in a radio show. Let me just put out the code section here. Radio. What's radio? It's a great question. But it all comes back to this section of the code. This is what's been charged. So this is the most important piece of it. When we're dealing with any of it, is we're looking to the charge itself. So, yes, popcorn. But we went through all of the evidence that's been set out in that indictment. Again, we have 32 out of 102 documents that have been charged. We have probable cause. We don't need proof beyond a reasonable doubt in order to go forward with an indictment. Excuse me. So you finished your popcorn. Glad to hear it. Oh, are these penalties added? The penalties just set out what the maximums are. There's no minimums for any of the charges. So, and that's just typical of how we put it on there, of how we add in to the very end, just to give the judge an idea, to give everyone an idea, because we base what level a felony is off of what the level of penalty is. Yes. Oh, you're welcome. I hope it was interesting. I think it's always interesting to just look at the evidence, figure out how are we going to get this into court? What is the jury going to say? What objections could we raise as the government? What could we ask? What could we object to as the defendant? So what kind of motions in limine could we have? What kind of issues could we have? Case number on what you started in the afternoon. The case number, it's this case. So it is this, this is the case itself. Let me just bring this up for you here. This is the case number, the docket that's set out in Florida. And you can pull this up. This is available publicly online for everyone, for anyone who is interested. Yep, exactly. Yep, you can pull it up and take a look and see what there is to see, and go check it out yourself. How do you acquire these documents? They're online. They are public. You just go click on the documents and pull them up. I just print them out and kind of go through them here because I think it's helpful for people to understand how this whole process works. And because I've done so many criminal trials in my life, I think, I try to just kind of explain how some things work. So hopefully it's helpful. But yes, Congress did say that, and the justice system is working its way through. But again, one of the essential pieces is that we do have a right to a fair and speedy and public trial. And so there are lots of public documents available out there. And so I find, I'll be perfectly honest, there are lots of great reporters and journalists, and I've got tons of respect for them. But what I find is that just even a couple sentences into them explaining something, it seems like they are on one side or the other. And to me, I find that distracting. So I find it helpful to I just want to see the court documents. I just want to see the facts. I don't need really the extra points of like, well, this was awful or this was, for me personally, I'd rather kind of make that decision for myself. So that's why I just preferred to pull these documents. And I thought, maybe other people would be interested too. So just kind of sitting down and talking about it that way, as opposed to kind of with that real angsty vernacular that's involved. I mean, I may have my biases when it comes to like, I can't believe the attorney filed that. I mean, I may have my own biases, but I certainly, want to make sure to look to both sides. Oh, you're welcome. You're welcome. You're very welcome. Oh, sure, sure. Hopefully this was helpful. I do put my lives up on my Tube of You channel for anyone. I think there was just a sweet, sweet woman who left a comment today that she had it running in the background when she was cleaning, and that just was the sweetest thing. I thought that was so sweet. I'm like, yes, if anything can help you clean, if I mean, going through court documents gets you to go forward and clean, good for you. I feel like I have, accomplished something with my life at this moment. So, while you chop dinner. Oh, yes, of course, of course. Yes, I think it can be helpful when you actually just listen to what the actual language is, as opposed to, someone kind of just summarizing. So you can pick it apart yourself. I may be right, I may be wrong, that's fine. But, just actually looking to the language itself, I think can be really helpful in people figuring out, how they want to go about it. Listen to like a podcast. Oh, that's so sweet. Oh, that's so nice. Oh, yes. I think it's good to kind of put ourselves in the shoes of the jury, and because they are our fact finders, and you are a fact finder too. So it's good for you to have information in order to make that assessment and decide for yourself. Had to stop doing the dishes to tell you I was listening while washing them. My goodness, thank you. Oh my gosh. Oh, well, I thank you for your service to the dishes. Nobody loves to do that. If no one has said thank you for doing dishes, let me say thank you for doing the dishes. That is appreciated. When will we have new information tomorrow? Yes. Well, the arraignment's tomorrow. I don't think anything big will happen tomorrow. I believe there's a hearing in Georgia. So I think that will be probably what's to watch. That's a contested hearing. But I think that's really it. I don't think there'll be too much going on tomorrow. At least I hope. I'm okay for a few days, taking a few days, and trying to figure some things out. What firm do I work with? I have my own firm. I am a solo practitioner, so I'm very, very lucky. I spent a lot of time working to be able to set myself up to be where I'm at now. So Tuesday, the eagle lands in Georgia. Oh my gosh, I can hear the eagle coming. Oh, I don't know what's going to happen. I'm nervous. I've been studying and reading and trying to figure out RICO like it's going out of style. And I tell you, that stuff's bananas. Absolutely bananas. Am I single? No, I'm married. I'm extremely married. I'm very married. But thanks for asking. It just flew past your house. The eagle. Oh my goodness. Oh my goodness. I think a lot of things are being tested right now. I think there's a lot of tests going on. RICO charges are easier for government to prove, though. There's truth in that. I think, again, just being able to prove a couple of criminal acts as opposed to the specificity we have to do with how we do single acts outside of the RICO system is definitely true. Have to work my way into that ring play collection. Oh my goodness. Oh my goodness. No, my poor significant other just pops his head in every once in a while and it's like, what are you doing? I'm like, never mind. Never mind. Don't pay attention to the lawyer in the corner. There's nothing going on here. So, the likes. Oh, thank you so much. Oh, look at those. I haven't looked at those. Thank you for the likes. I appreciate that. That's so kind. That's very kind of all of you. I'm very thankful. Great use in civil actions. It really is. You're right. Mail, phone, across state line for shipping. It's got huge civil court moments. Absolutely. So I'm wondering too, if it doesn't go criminally, then we could take it down that civil road too. My Tube of You channel is the same as my name here. So it's the same and it's nothing fancy. I just literally upload my lives so people can, if they come in at different times, you can fast forward to whatever's interesting and so on. You can kind of check that out. Will there be transcripts from the trial once it starts? No, it's okay. You can yell. You're blowing my hair back with your caps. No, I'm just kidding. Yeah. No, I really have no idea how they're going to handle that. How they're going to handle the transcript situation. And we've got two very different judges with DC and with Florida. So, I think the next couple weeks will be telling about how the judges want to deal with that. But I'm not sure. Should DC be televised? I'm not sure either of them should be televised necessarily. I truly trust the judges to make the best decision for due process. And, again, that's the goal. We need to have a fair trial. We have to have a fair trial. That's so important. Absolutely so important. So I'm not sure. I truly, believe enough in these judges to believe that they'll make a good choice on what needs to happen so we can have a fair trial. I think a lot of people would prefer them to be televised, but again, I think if by televising them it somehow hinders the process of getting this fair trial, then that would be a misservice of justice for the defendant. It wouldn't be right, because he has an absolute right to a fair trial. I think there will be a lot of circus-like elements. Can I just say that? I think there will be some circus-like elements. We're already trying to see it. We're already seeing some circus elements. So I wouldn't say we put it past it, but the other thing is, though, this will probably be a couple of the biggest trials, of my entire life, and, maybe other people's as well. But it's huge. It's a huge, just from a legal academic point of view, it's just enormous situation, historic. And so that's why I think it's so important to really walk through it and look at it and watch it carefully to make sure it's handled properly. We have live access on to the hearing somehow. I don't think so. Does his lawyer have a strong win record? I don't know. I've not looked up his attorneys. I probably could, though. But I kind of saw him over the weekend, and I'm not sure. I'm not sure I want to dig much deeper. But I'm not really going to access any of that. I really look just at the record. Like, if it's not, I know there's been some talk about, memos and stuff, but if it's not part of the docket, I'm really not taking a look at it. And even if it is part of the docket, if I think it's kind of, I'm not sure, that's a little hinky, I might take a moment to think about it. I turn pens. Let me make you one for a live. Oh my gosh, I'd love to. I would love that. Absolutely. Oh my gosh. Yes. Just, catch me in a comment, catch a comment on one of my posts, and we'll talk. But that would be so sweet. Oh my goodness. How come you don't put down your real name if you're a lawyer? Well, I don't do business through TikTok. I don't do any business through this account. And I have, even before, when I started posting, I had some problems with some people that were not very respectful of boundaries. And so for the safety of myself and my family, I just kind of keep that to myself. I do know that, there are other attorneys and other people who do know my name and so on. And so I've just asked them to, remain respectful of that. And so they don't put that out into the public. And I'm thankful for that. Why are you not putting your name? Do you have something? I do. I have my safety. So I do hide. I do protect myself and my family. So, and not to say that anything bad would happen, but I've seen enough in my lifetime to know that it could. So I do try to remain anonymous, although with the checks in place of, other attorneys and my ethics. And I have several attorneys that come to me after my lives and talk to me and in my jurisdiction. So they kind of keep me on my toes, and I'm thankful for that. So I do have corroboration, accountability in my sphere, but I do keep some things private. Have a great night. Thanks again. Oh, you're welcome. You're welcome. You have a great night too. You have a great night. Yep, I just don't put my personal information out. I think some people can, and I've got no problems with that. Yes, goodbye, goodbye. But I just don't. I don't, and I haven't ever. In fact, it took me about 2 months before I even put this title. Before this, my TikTok name was U.S. Law 101. I didn't even have any identification. So I did finally add in a little bit of my name so that I had other attorneys that had kind of told me I should be all right. So, and I did. I think that's okay. It's okay. I don't, I mean, to each their own. I think, oh, thank you so much, CJ. That's very kind of you to say that. I appreciate that. I do appreciate that. Thank you. Yeah, no, I don't mind. I've really kind of been there, seen that, when it comes to what goes on in the world. I've really seen a lot as a prosecutor, as defense counsel. So I've pretty much seen, it takes a lot to surprise me. Yes, I think it's hard to hear things that go against what you think is true. I think when someone corrects your truth, it's painful. And at least it is for me whenever my truth gets corrected, like, wait a minute, I thought that was how that was, but it's not. Okay. I mean, it's a kind of a painful process. Yes, and it, it was a college course-esque. Yes, it was, but it took me a little while. I'm shy, so it took me a little bit before I was willing to kind of share a little bit more of my of my world with people. So, um, which has worked out just fine. But I do try to kind of keep some things to myself. I try to have, yeah, an open mindset. I think that's really important. Um, oh, I'm so glad. I'm so glad to hear it was helpful. I'm super glad to hear that. That's really my goal. That is absolutely put a lot of emotion. Yes, and I understand why there's a lot of emotion there, and I really do, and I can respect that. Um, oh, thank you. Well, a scholar. Oh, nice school. Oh my goodness. Oh, well, I hope it was. 11 million pages of documentation. It feels like that. It feels like that. I do not want to tell you how much ink I've gone through. Don't get me wrong, everything's recycled, but oh, it's been a lot of ink. I think that was the only thing that raised my significant other's eyebrows during this whole process, because he looks at me and I'm in my corner and he's like, okay, whatever. But the other thing was like, you need another ink cartridge? I'm like, I know. Don't judge, don't judge. But oh, yes, I think if you're wrong, if you're thinking something wrong, that's fine. Just, fix it. Just, learn better, do better. I mean, that's nothing to be ashamed of. I make mistakes all the time. Absolutely. And I'm glad to be corrected, because I would rather be corrected than continue on with the incorrect knowledge. I'd rather know what the real thing is. Oh, thank you so much. That's so kind of you. Thank you very much. I appreciate that. How do we know when you'll be presenting another document? Well, this one I did put out kind of a notice, because I wanted to make sure everyone could come by tonight. But if something new gets filed, I try to come on and explain it. But at this point, unless something really significant comes on within the next couple days, I probably won't be back on right away. I'll probably really need kind of a major document. So if another major document drops, like we had that warrant that dropped this morning, and so I was able to do a post on it, but I'll probably just kind of weigh things out and see what we need and so on. But sometimes people just make requests, and I'm like, oh my gosh, that'd be perfect. Let's do that. So I am putting together a list of some cases that I'd like to go through on my lives to kind of give people an idea of what order I'm going to be doing things in. So I should have that posted relatively soon. Oh, you're welcome. You're welcome. When I have a chance, can I go over habeas corpus? I can do that. Let me put it on my list. I've got a couple of posts, and so if you actually look through TikTok, you can find posts on habeas corpus where I've explained that. And I've got a couple cases that I've talked about that also. So that can be helpful, I think, too. But yeah, I'll put it on my list. And like I said, I am putting together kind of a schedule of my lives that are not, specific to the indictment. They, I do all kinds of lives on the Constitution and on different case law and so on. So I'll kind of be putting that together soon and have a post up so we can kind of refer back to that. So hopefully that'll be up within the next couple of days. Oh, thank you. Oh, thank you so much for all the likes. I'm very thankful for that. I appreciate that. Yes, I think it's just about time. Just about time. Last night's live went so long. Oh my gosh. I think, where'd we go? 5 hours last night? My goodness. Yes. So, I might just do that, Raymond. I might just do that. Yes, you're welcome. You're welcome, everyone. I'm so thankful for your time and energy, and hopefully this was helpful for people. Oh, good. I'm so glad to hear that, Rosie. I'm really glad to hear that. Yeah, I think it's super helpful to understand how evidence works, and oh my gosh, yes. Oh, we'd be in the bushes. Oh my gosh, the bushes are going to follow me everywhere. Oh, I love that. I love that. It's okay. If yes, I will be. It takes a little while. Actually, it took overnight before I was able to load up yesterday's. I think it was because it was so long. So it might take me a little time to get everything loaded, but I do try to load it up and get it put up on the Tube of View channel as best as I can. So, well, I'm glad to hear that. Learning a lot. That's what I love to hear. I love to hear that. Yes. Oh, I'm glad to hear that. Oh, good, good. Mm-hmm. Yes. Oh, I have just complete and total trust in my mods. I'm so thankful for my moderators. Thank you all for being here. Oh my gosh. Yes, yes, they will all be up and up and going. So, I think, oh, sure, sure. I think I will go ahead and sign off at this point so I can go forward and kind of keep working on getting everything uploaded. But thank you again, everyone. Feel free to pop on over to my Tube of View channel. You can leave a comment there too if you've got questions and whatever. I'm happy to chat over there as well. So yes, that's a lot of likes. Oh my gosh, thank you so much. Yes, thank you. And thank you so much, VC. I'm so thankful for your time. I appreciate it. I appreciate it. But yes, it's the same as my name here on TikTok, and you can catch me over there. And I kind of linger over there a little bit too. But yeah, as we have more information coming in, I will be back to discuss it. And anytime you want to tag me on anything, if you've got questions, I'm also very, very happy to help as best as I can. So, oh my gosh, 130. Oh my goodness. Oh my goodness. Oh my goodness. Oh, thank you, everyone. Thank you, everyone. Have the best of nights to everyone, and I will catch you all later. Yes, 130. Oh my gosh. Oh my goodness. Yes, take care. Best of luck. I will be back on again.